May it please your Lordship. Your Lordship, I beg to mention item number 34, Your Lordship. It's a joint request, Your Lordship.
Number?
34, on behalf of Mr. SN. It's a joint request, Your Lordship. After vacation.
On pre-made by the parties. This is met after 3 weeks.
Obliged, Lordship. Your Lordship, similar play of item number 23 to 29, Your Lordship. The conducting counsel, Mr. N.D. Shulai, he's on bereavement, Your Lordship.
What is this? What is required here?
Lordship, in this matter, I have received the affidavit filed by the new implemented respondent, Lordship.
So you have to file your rejoinder?
I'll seek instruction.
Not necessary.
But if required, Lordship, we'll be filing, Lordship.
Let the matter be called up.
Okay.
As far as hearing is concerned, maybe we will not be able to take it up. But if submissions are there, we have to acknowledge the affidavit filed by the respondents, so on and so forth. So,
Obliged, Lordship.
Lordship, I beg to mention item 33. Bring for 1 week time, Lordship.
this is a very old matter.
Yes, Lordship. Conducting counsel is having one part heard matter in courtroom number 1. The conducting counsel is having one part heard matter in courtroom number 1.
On pre-made by the petitioner. This is matter after 2 weeks.
I pledge.
Excuse me.
Please, Lordship. So I'd like to make a mention for item 30, Lordship. Item 30.
13?
Yes, Lordship. Lordship, I'm...
One 3.
30, Lordship. Bring Lordship, I'm praying for some accommodation, Lordship, this matter. Is it after Puja, Lordship? As
Yes,
a
you're not
last
interested.
chance, Lordship.
I think there's an issue of law to be decided here.
Lordship.
Actually, what is there? Is this with regard to the not the order passed by the Revenue Board?
No. Your Lordship, the power of Darbar should know. CM
Territorial.
name also is important. State has got limited role. So basically, it's, and as I submitted, Lordship, in the last occasion, it's got far-reaching effect.
That jurisdiction.
Yes, Lordship. It's far-reaching effect because it will affect whole of East Khasi, West Khasi. So they've been asking for time, and we don't have problem. Lordship. Only thing is if they decide this, otherwise.
Sooner or later, it has to be decided, disposed of. If not now, at least 15 years hence, we still have to decide it.
But they're waiting for puja, Lordship. Maybe after blessings,
puja, Lordship.
after religious blessings, maybe they'll have more illumination.
Yet again, the petitioner has sought for accommodation in this matter on the grounds of personal difficulty of the learned conducting counsel. Time and again, this court has reminded the parties that this is matter which is pending for quite some time, and it is incumbent upon the Learned Counsel to ensure that the matter is heard. However, on the ground so stated, the prayers allowed. This is matter after 3 weeks.
Obliged, Lordship.
Exactly. Obliged. Very true.
From the list, item number 1.
Yes. Lordship, this is a bail application. Lordship. Also matter, Lordship. Lordship, I'll take steps from the complainant.
Thanks.
But Mr. MLMP Learned Counsel for the petitioner was submitted that this is an application for grant of bail. The petitioner himself,
He's the accused person.
grant of bail in favor of the petitioner herein. However, the Learned Counsel would submit that before the matter is heard, notice may be allowed to be issued upon the respondent
First
number 2.
matter.
The respondent number 1 being duly represented by the learned PP. And as such, no further notice is required to be served upon this state respondent. On premier, the same is allowed. Let notice be issued. The same returnable within
Sadhya after, no?
10 days.
So I may be permitted to take personal service as well by Dusty.
As prayed for, let notice be issued, including personal notice.
I love Lodge.
Item number 2.
2 to 16 connected matter.
May it please, Lordship. Yes, my Lord, I am before this Honourable Court for modification of bail condition. I was released on bail on the 28th, 2024, and the condition that was imposed was that I have to furnish 2 sureties. But my Lord, since I'm from Bangladesh, it caused great difficulty for me to procure bailers. So that's why, my Lord, I'm before here as this Honourable Court, an earlier occasion also has, there are cases where this Honourable Court has allowed cash deposit. So for similar modification, we are before this Honourable Court. And my Lord, I was arrested on the 16/6/2024. The FIR is, if my Lord can kindly come on Annexure 1 in the FIR. My Lord, if I may read with your permission. It says, with reference to the subject cited above, I am to report that last night I was deputed for night Naka checking duty by the officer in charge of Dauki PS along with other staff on received information from the reliable sources that some Bangladesh national likely to enter Indian territory through unfenced international border. On received the information and as instructed, myself and staff conducted Naka checking laid on ambush near Dauki boating point at around so-and-so, one Innova tourist vehicle number so-and-so proceeding from Dauki towards Benorsa side. On stopping and checking, it was found it's occupied by all so-and-so except the driver. Shortly after 15 minutes, one more Innova tourist vehicle bearing registration number so-and-so arrived at the Naka checkpoint, and the second vehicle also consists of occupant of Bangladesh national except the driver. On questioning the spot, they could not produce any valid documents for identity and their entering into the territory, hence they were brought to Dauki PS for proper investigation. Further, to report that 4 ladies were with their 5 minor children, submitted for your kind information and to register a countable case against them and for further investigation. Here, my Lord, the name of all this person who were arrested is mentioned. My Lord, if my Lord can kindly come to the serial number 12 of the accused who was arrested, my Lord will see that this person was arrested, Srimati Libani, 22 years, along with her daughter Janat, 5 months old, and her son Arafat, 6 years old. Similarly, my lord, serial number 13, this lady was arrested with her son, 6 years old, and item serial number 14 also, her son 2 years old, and serial 15, her son 2 years old. So now these children are also there, my lord. They are taken into custody along with the mother, and now they are in district prison, my lord, in July.
They have been released on bail.
Yes, already released on bail. The order is, my lord, can you come on page 12, my lord?
Okay, so now they have been released on bail with certain conditions.
Yes, my lord.
But since those conditions have not been complied with, so they are still in custody.
Yes, my lord. Yes, yes. And my lord, they were released on by this order, my lord, of the Judicial Magistrate First Class Amlaram, order dated 28/2024. My lord will see the condition that they have laid down here, my lord.
Where is the page?
Page 13, last page, my lord, page 13. My lord will see the second paragraph, my lord. It says the statutory period of, my lord has it?
Yes.
Yes. The statutory period of detention of accused person as provided under section 167 of CRPC has expired. Hence, this court is inclined to enlarge the accused person on bail on execution of a PR bond of rupees 20,000 with 2 sureties of the like amount, and same condition of order dated so and so by honorable court shall apply. So basically, we are only asking for modification of this condition of 2 sureties, my lord, because now we have been released on the 20 of August this year, and now for 1 month, my lord, we have been trying to contact our relatives from Bangladesh, but they are not able to come.
But have you have not moved the the same court for modification?
My lord, this is passed by the trial court, my lord. So for it's either the High Court or the Session Court. Why we have not approached the Session Court, my lord? Because the Session Court also, in one of the cases, my lord, in this same PS case, my lord, they have granted bail and have imposed similar conditions. That's why we are before this honorable court. Item number 11 is the case where the Session Court has granted bail, my lord, with similar conditions. So that's why, as per the law, my lord, the old provision CRPC was 439(1)B, but now BNSS it's 483(1)B, where this honorable court has the power to modify conditions, my lord. And my lord, judgments, my lord, in earlier occasions, my lord, there was some Nigerian. There were some Nigerian nationals who were arrested, my lord, and similarly similar condition was imposed, and they were before your lordship, and your lordship was pleased to direct that there will be a cash deposit and exclusion of sureties, my lord. My lord will see paragraph 11, 12, 13, 14, my lord, 15, 16.
Are they all passport holders?
My lord, I doubt that they are passport holders.
And how do we ensure?
My lord can impose.
Even if they are allowed to, they may deposit cash.
Yes, my lord.
What happens is that would amount to a quid pro quo situation where cash is deposited and they are set at they set free, and they can disappear or go back. Or
I understand that difficulty, my lord, but my lord can impose condition that we can report to the police station after every 1 week or 2 days, my lord. Because now this is a humanitarian crisis, my lord. We have been granted bail, but the same bail conditions are causing difficulties for us for being released. And children are also involved, my lord, in this case. In 4 similar cases, my lord, the children are also in custody with their parents, with their mother. So, my lord, if there are judgments of the Honorable Supreme Court also which says that bail conditions should not be such that it will cause a situation where poor people are not released from custody, my lord.
Well settled.
Yes. My lord, I'll just place that also, my lord. Motira. But I think this is the...
You're referring to Para?
Yes, my lord, this is the case where Mason was granted bail, my lord, by the Supreme Court, and they have given him to approach the magistrate, and magistrate puts a condition that you have to produce sureties. So, my lord, I'll take, my lord, to the relevant paragraph, paragraph 23, my lord. 23 onwards, 23 to 26. With your permission, my lord. Paragraph 23, my lord. It says, semantic smoke overlays the provision of bail in the code and prisoners' rights when cast in ambiguous language becomes precarious. Where doubts arise, the Gandhian talisman becomes a tool of interpretation. Whenever you are in doubt, apply the following test. Recall the face of the poorest and the weakest man whom you may have seen, and ask yourself if the step you contemplate is going to be of any use to him. Law at the service of life must respond interpretatively to raw realities and make for liberties. Primary chapter 33 is the nidus of the law of bail. Section 436 of the code speaks of bail, but the provisos makes a distinction between bail and own bond without sureties. Even here there is an ambiguity, because even the proviso comes in only if, as indicated in the substantive part, the accused is a bailable offence is prepared to give bail. Here bail suggests with or without sureties, and bail bond in section 436.2 covers own bond. Section 437.2 bluntly speaks of bail, but speaks of release on bail of person below 16 years of age, 6 or infirm people and women. It cannot be that a small boy or sinking invalid or pardon a nation should be refused release and suffer stress and distress in prison unless sureties are hailed into a far-off court with obligation for frequent appearance. Bail there suggests release, the assent being on undertaking to appear when directed, not on the production of sureties. But section 437.2 distinguishes between bail and bond without sureties. Section 445 suggests, especially read with the marginal note, that deposit of money will do duty for bond with or without sureties. Section 441 of the code may appear to be a stumbling block in the way of deliberate interpretation of bail as covering own bail with and without sureties. Significantly view, it uses the word bail and own bond as antithetical if the reading is literal. Incisively understood, section 441 provides for both the bond of the accused and the undertaking of the surety being conditioned in the manner mentioned in the subsureties. To read bail as including only cases of release with sureties will stultify the subsection, for then an accused release on his own bond without bail, that is surety, cannot be conditioned to attend at the appointed place. Section 441 clause 2 uses the word bail to include own bond loosely as meaning one or the other or both. Moreover, an accused in judicial custody, actual or potential, may be released by the court to further for the ends of justice, and nothing in section 441 compels a statutory meaning. Section 441 clause 2 and 3 use the word bail generally because the expression is intended to cover bond with or without sureties. And my lord, will see that in paragraph 34, the Honorable Supreme Court says that they have released this person on his own bond and the sum of rupees 1,000, doing away with the condition of sureties, my lord. So, my lord, this is a classic case where a poor person has been detained, my lord, and then because of they have been released on bail, but because of the bail condition, now it's causing great hindrance for them to be released. Now, procedure cannot be a tool to cause further inconvenience, my lord, especially in the case of liberty. And my lord will take into consideration also these are connected matters, my lord, in item number 6, my lord, item number 8, item number 11, and item number 12, my lord. Here, children are also involved, my lord. Well, I've prepared a note to check it. I've mentioned the details, my lord. In all these cases, my lord, they have been released by the same order, except in
Item 11.
11, my lord. Item 11, he's been released by the district and session judge, my lord. Otherwise, all of them, they are being released by the same order, my lord, 28.
Yes, Mr. Khan. What do you say?
Actually, factually, the situation is slightly different because we have to have an independent consideration so far all these cases are concerned. In view of Lordship, my learned friend has relied on your Lordship's judgment. If we come to para 14, Lordship.
Yes.
What very important aspect is this, Your Lordship. From the records, it is noticed that the passports of petitioners has been seized. And as such, they are effectively in the custody of the court of the concerned authority. Lordship, allow me to pause here for a minute. So, this judgment, when this Honorable Court modified the conditions and resorted to 445 for deposit of cash, this court was seized of the matter that the valid passport of these people are seized with the authority. And without passport, Your Lordship, any foreigners who come to India without a passport, neither he will be able to leave, or even if he leaves breaching the terms condition, it will be very difficult for him to survive anywhere. So that was the only saving grace when this court modified. So in the absence of that passport, Your Lordship, as a Lordship, what has fallen initially when my friend submitted was this: when 445 is modified and a cash has been deposited, in this case, neither they have a passport, no valid documents, no anybody from the families in Bangladesh have come, and they are not in the position even to get some assurance from the Bangladesh embassy as to their presence will be confirmed. So A, B, C, D, there is nothing on record that the police have seized from them to show that if released on bail, their presence for trial can be assured. So we are in a very peculiar situation. There is no documents. Had there been maybe some documents and some stakes in the trial, so the situation is slightly technically Lordship in the sense that once the condition is modified, they deposit the money. It's almost like by a default bail and the condition imposed, they are acquitted. So in a country like ours where things have to be decided as per rule of law, and the charge has been clearly framed under 14A and C, there is nothing before the court to secure their presence, not any iota of document. So factually, this is a very difficult situation. Lordship, second part of this, my learned friend had relied on a Supreme Court judgment, 1978. It's been 46 years, few days, and on 18th September, Honorable Supreme Court has reiterated the same thing. I just give it to Your Lordship. It has further clarified it. Yeah. Now, why this two judgment is important, Your Lordship? If you come to para 6.
Yes.
So after 46 years, the Honorable Supreme Court revisited this particular aspect on 18th September. And it says it would be travesty of justice if the petitioner is unable to secure the benefit of bail order for his inability to furnish local security. This will infringe the rights guaranteed under Article 21 of the Constitution for the person who continues to be detained despite the bail order in his favor. Having considered the circumstances here, we deem it appropriate to say that the petitioner be released on bail on his personal bond without insisting on local surety. To ensure compliance with this court's bail order dated so and so, it is ordered accordingly. Actually, my purpose of reading out this is this: I just wanted to clarify the issue of law. That even in personal security, personal bond, if for some reasons you can't do it, court has to secure that. Now, there are very important aspects in both the judgments, Your Lordship. Both the judgment concerns Indian citizen. Both the situation, Your Lordship. It does not concern a foreign national. So nobody is having two opinion on the issue of law and on the issue of bail or bail bond or travesty of justice. But then we have a fundamental situation. The only saving grace that we have is in your lordship's order. In fact, that is the most appropriate order. The other aspect, law is very clear.
That is also, you see, where there is a passport.
Absolutely.
Here,
So lordship's order will be guiding light for us in this case is concerned, because in that case lordship had fortified its argument and it resorted to 445 in cash deposit on the ground that there was a passport in possession. So whether it's Motiram or whether it's 18 September 2024 judgment by the Honorable Supreme Court, travesty of justice should not happen because somebody can't give the bail bond. But both the judgment concerns an Indian citizen. The issue of passport was not involved. The issue of giving assurance from the embassy was not involved. The issue of any other valid documents without which the mobility will be restrained was not involved. Now here we have a situation, if two local sureties are not given or somebody from their country with a valid passport doesn't come, assuring it, then Your Lordship, if we resort to 445, by default it will amount to acquittal because they are not going to come back. There is nothing to bind them.
It's casting a person on us, my lord.
No.
It's not that we will escape. Now you've already presumed that we'll escape.
No.
Now if, my lord...
For a moment, let me just complete it. For a moment, I'm not casting aspersion. I'm saying there's nothing before the police or before the court to assure that their presence during trial will be guaranteed. That is what I want to bring the clarity. No passport, no suggestion from the Bangladeshi embassy, no assurance from any local bailers from their country. Above that, no local surety from the country. Now we have only one condition, if this Honorable Court modifies, would be you deposit cash. Assuming Lordship does it, in that case there was a passport element, but in this case we have a factually different situation. Assuming this Honorable Court does it, not for a moment I'm saying the court should not do it. I'm not going to do that. What I'm saying is if the court does it, how do we secure their presence if the trial goes on? And in case they jump, I'm not casting aspersion, in case they jump, Lordship, we resort to the bail provisions under the Act. The bail bond is forfeited. The local sureties, warrant has to be issued to the local sureties. These are the normal procedure involved. In this case, what do we do if the cash is deposited? Then they don't stand. Then they don't come and stand trial. What will be the option for the court to secure the presence? No local sureties. Nobody from the Bangladesh who's coming to guarantee the presence, and then there will be no bail bond that can be forfeited because there is nobody from India. Now we have a very important issue involved here, Lordship, is this. It does not concern any Indian citizen. It is not so simple as it appears to be. Both the judgment addresses an Indian citizen. We have a very technical situation, no documents, but it involves a foreign national. In that situation, this Honorable Court, and my persuasion will be, Lordship, this Honorable Court has to tread very carefully and cautiously, because in the absence of those vital facts, this will become a precedent. And then securing the presence could be a matter of challenge. Not for a moment I'm saying they're jumping it. In case they do, what would be the power of the court to seek their presence in the court? I'm afraid, Your Lordship, other than that 445 deposit of money, there will be nothing.
see, Mr. Shila,
Yes, my lord.
you have to consider the scenario as it is.
Yes, my lord.
Firstly, prima facie, it has been established that they are foreigners. That is what is apparent from the records. Now, secondly, they have no papers with them, passport or otherwise. Number two and number three is assuming that they are foreigners. We don't know what is the reason they have come across to India. They have no source of employment here, no source of income. Where is the the record that they are employed somewhere in this country? It's not there. If, as Mr. Khan had said, if they are allowed to be enlarged on bail, where is the assurance that they will not skip bail? You see, because the factor of a flight risk is very much apparent as far as bail jurisdiction is concerned. The court more often than not would allow a person to go on bail on the assurance that he will not abscond. And for that, of course, conditions are being set, and one of the conditions for sureties to be present, whatever. In your case, you said you have no local surety. If you could ensure at least one local surety, that would be enough. But it's not so in your case.
Yes, I understand the anxiety expressed by the learned prosecutor as well as by this honorable court. So, my lord, can you give me time to take instruction, my lord?
What you can do?
Yes, my lord.
What you can do, Mr. Khan also can help here. Since they are foreign nationals, the High Commission office should be informed of this situation. They should come.
If the state can help us out that way, my lord.
Lordship, if I may just assess the court, just recently, again, 10 days back, Honorable Supreme Court, there was a condition in the bail matter where conditions was imposed, getting permission from High Commission. High Court had imposed that condition, Honorable Supreme Court has struck down. So just recently, 10 days back, in a similar matter. So his issue would be, Lordship has rightly said, if he can make an attempt to get one surety. If not, Lordship, we leave it to the discretion of the court. There's already order.
You get that taxi driver also. 5.
My lord, another issue here, my lord, it slipped my mind, my lord. So far as item 11 is concerned, my lord, he's an Indian citizen, my lord. So the prosecutor has fairly...
In Indian citizen, Lordship, then 18 September judgment will be applicable.
Yes, my lord. He's an Indian citizen. Then I'll file a affidavit also next date, my lord, to bring his epic as well as this Aadhaar card, my lord.
11 can be handled independently once you bring the epic.
Yes, my lord.
Then 18 September judgment will be applicable. Yes.
So I'll take instruction, my lord. So
no local sureties is required after this.
See, this court is not without, let's put it this way, not without our heart.
Yes, my lord.
Considering that the minors are involved, we do sympathize with them, but sympathy and empathy will not help us.
I take your
what the law
lordship.
says that will matter.
I bow down to that, lordship. Your lordship concern is regarding flight risk. So I'll try to take instruction if we can somehow, if they have passports or some local sureties, just one.
Absolutely.
So we'll inform.
He files an affidavit and brings to the recorded lordship can modify.
Yes,
because that's covered by your lordship's order only.
Yes,
You see, as far as the modification of the bail conditions concerned,
there's no issue into
this. As Mr. Khan has conceded,
lordship, 2 sureties has been dispensed with by Honorable Supreme Court just on 18th. He says nothing doing personal bond, you can do it. And a very, very strict guidelines has been given. The first time we decided this matter was in 1978.
Because the principle will also be applicable as far as UTPs are concerned.
Yes, Lordship.
I think just recently there was
the number of state of UTPs that are in.
So, Your Lordship, after 18th September 2024, after the Honorable Supreme Court judgment, most of the UTPs can be released on personal bond. Only thing they have to satisfy is they can't have local sureties, but in his case, slightly different.
Except with serial number 11, item number 11.
File a epic.
So I'll file my epic and Aadhaar card.
In fact, the Supreme Court judgment will guide you. 18th September judgment will guide
Pick it
you.
up on Friday.
My lord, if it's possible on Monday, my lord, because it will take some time, my lord, for us to arrange.
What Mr. Jaisalal and counsel for the petitioner, as well as Mr. K. Khan, PP. On hearing the parties,
You call this no? Keep it.
in course of the hearing, the learned counsel for the petitioner has sought for time to
Just mail me this too.
seek instruction so as to clarify certain queries made by this court. Vis-a-vis the bona fide of the petitioner. On premises, she was allowed. This is matter of 30th Monday.
Lordship, on a lighter note, this court expresses mind that the court has got a heart. And Your Lordship, when we hear the 2 years, 3 years old child involved, so my heart was beating faster.
They cannot be. You cannot expect them, to be
Absolutely.
confined.
Yes, my lord.
In a prison like situation.
So when my heart was beating fast, I was just thinking, how should the Supreme Court judgment help him?
My lord, in fact, that was the main consideration why we have approached this honorable court, my lord.
Yes.
Due to this humanitarian
And
crisis.
an
that we are
interesting
facing.
issue of law is involved, Your Lordship. Yes.
Mr. Singh, we have come a bit too late. We have waited for 1 month.
No, we have tried, my lord, to arrange local shorties for 1 month. We were trying, every effort was made to at least trace just one local shorties also, my lord. But we have not been successful so far.
In the Lordship judgment, Lordship is modified to 1 surety.
Something like that. Yeah. Because you see, as far as the lower court, the trial court's order is concerned, there is no. This court has no grievance with that.
Yes, my lord. In fact, we don't have grievance, my lord.
Except for the fact that the condition may have been a bit stringent.
Yes, my lord. Yes.
As far as your situation is concerned.
Yes, my lord.
Oblige, Your Lordship.
Oblige, Lordship.
I'm grateful.
So this will be from 1 to
2 to 16, you know.
2 to 16.
2 to 16.
Item number 17.
Oblige, Lordship.
Please, Your Lordship. Your Lordship, this is the second bail application, Your Lordship, that I'm preferring for the accused person. The first bail application was moved by the sister, and the petitioner here is the father of the accused.
NDPS?
The NDPS, Your Lordship. This matter is from East Jantia, Your Lordship. The trial is going on.
How many witnesses?
4 witnesses have been examined, Your Lordship.
Total?
Out of 7. Let me just check. All the witnesses except the police Caesar witnesses and the IO is left, Your Lordship.
Only 2?
No. What is left is the Caesar witnesses.
So how many more witnesses are left?
For Your Lordship. Five more left, Your Lordship. These are all the
official witnesses.
Official witnesses, including the IO.
When was the last evidence recorded?
The last evidence was recorded, Your Lordship, it was this month. I could manage to enclose only the deposition of 3 witnesses, Your Lordship. The 4th witness.
Just you see, the court just want to know the date.
Your Lordship, it was this month, but with the date, I'll take some time, Your Lordship.
See, Mr. Jurwa, firstly, this is a case of commercial quantity.
Yes, Your Lordship.
So, Section 37 will.
Yes, Your Lordship. I'll try to satisfy Your Lordship on that aspect.
Now,
Oh,
you may, you see, whatever you say, the situation is such that when there has been, a well-established prima facie case has been made out against the accused, it implies that he is guilty
Yes.
until proven innocent.
True.
And how is that to be done? It's only the trial that will, tell. Now we are at the stage where the trial is going on.
Yes, Your Lordship.
At best, what you could do is wait for the trial to be completed.
If Your Lordship
It may not
permits
be.
me.
It may not be. You see, it may not take that long. It may not take.
If Your Lordship permits me, so far, Your Lordship, 4 witnesses have been examined. From the materials available on record and also the depositions, Your Lordship, of the witnesses so far have been examined. There's nothing against me. On the first round of my bail application before this Honorable Court, Your Lordship, I was banging on the CDR because there is only one evidence against me which the prosecution is relying upon, and that is because of the CDR. My number was there in the co-accused number, and at that time when the vehicle was intercepted, I was the occupant. I was inside the vehicle. It is a tourist vehicle, number one, Your Lordship. I was traveling from my hometown to Guwahati. I have documents to show that my family are there. My children are going to school in Guwahati, Your Lordship. And at the time of interception, since I was there in the vehicle, and on checking the mobile phone, the number was there in the co-accused number. They made out a case of section 29 that I'm also involved in abetting or conspiring to commit an offence under the NDPS Act. Apart from that, Your Lordship, there is nothing. And Your Lordship, if Your Lordship come to the deposition, Your Lordship, page number 184. This is the deposition, Your Lordship, of the officer. He's a gazetted officer, Your Lordship, who received the information from some source that there was a vehicle traveling contraband. So he's the person, Your Lordship, who first received the information. At page 184, Your Lordship. I'll just read the relevant portion, Your Lordship. From the 6th line, Your Lordship.
Yes.
The bottom 6th line. It is a fact that I was part of the search and seizure team. It took about 1.5 to 2 hours to complete.
It is a fact?
It is a fact that I was part of the search and seizure team. It took about...
Where we are reading from?
This 184 page, Your Lordship.
Cross-examination?
Cross-examination from the 6th line below. The last 6th line, Your Lordship. The last 6th line.
Last 6th line is...
I reached the Naka station at around 5:15, and the IO was on his way. 3 officers of the ANTF team, namely SI so-and-so and SI so-and-so, along with me and SI so-and-so, proceeded to the Naka station. It is a fact that I was part of the search and seizure team. It took about 1.5 to 2 hours to complete search of the vehicle, as contraband were hidden in various hidden compartments of the vehicle. Your Lordship, I'm just a passenger in the vehicle. The vehicle was a tourist vehicle, and the contraband was found from a hidden. It took 1.5 to 2 hours to discover the contraband. Because why? As per the statement of this very important witness, Your Lordship, they were hidden in various hidden compartments. So at my first bail application before this Honorable Court, Your Lordship have discussed on conscious possession. Your Lordship, this very fact that it is in a hidden compartment, and apart from the CDR, there's nothing against me. There's nowhere, Your Lordship, no evidence whatsoever available on record to show that I have knowledge that that contraband was there in the vehicle, so as to implicate me also in this incident matter under section 29 or otherwise. It is a tourist vehicle, number one, and I was traveling from my hometown to meet my children in Guwahati, and I have annexed, Your Lordship, the school certificate of my children. They are there in Guwahati studying because of the ongoing conflict in my district, Your Lordship, Chorachandpur. I had to shift the schooling, so it was the to and fro that was going on, Your Lordship. That's why I had a contact number with this person, because with the co-accused, because he was a tourist driver. I was unaware of the contraband that was there, and from this and from all the materials available on record, Your Lordship, even in the charge sheet, the only point as to why the investigating agency have arrested me is because I was in touch through the CDR. The CDR shows that I was in touch with the co-accused. Apart from that, there's nothing. So, Your Lordship, prima facie, there's a reasonable ground that I'm not guilty as per section 37. When we talk about 37, Your Lordship, a reasonable ground to show that I'm not guilty, that will be enough for me to grant bail. Lordship, this is my humble and respectful submission that on perusal of the record, Your Lordship, there's nothing against me. And there are, and I would like to Your Lordship, when it comes to conscious possession, Your Lordship, I'll just like Your Lordship to take Your Lordship to Section 35 of the NDPS Act, which talks about the knowledge, Your Lordship.
Mr. Can we continue this?
Your Lordship.
Mr. Khan?
Or maybe Lordship next week. In the meantime, let me go through it also.
Resume later. In the meantime, I'll get the instruction on the last date of the matter.
No, Lordship, why I'm saying next day, Lordship? See, 362 CRPC clearly bars this Honorable Court to review on facts. If the earlier bail petition was rejected on facts, my learned friend may not be allowed to raise the same facts. The only limited ground for him would be, since the last order till now, how many witnesses have been examined, and whether there's a case of delay, and how many witnesses have been examined. And then he has to just present whether those witnesses say some facts which doesn't favor the prosecution. So it's the only limited ground. Otherwise, if he goes into the entire merit,
Exactly, that's what he said. That's what he said.
that can't go into, because this court will not be reviewing its earlier order.
What he's saying in effect is, if I understand correctly, the change in circumstances would
Exactly.
be,
Yes.
would
So
be the deposition of the witnesses.
Let him bring the deposition, Your Lordship, and we'll argue on that.
Your Lordship, I brought along with my
So,
petition.
Lordship, let him have it next week, Your Lordship. Please. And let me go through the deposition.
Your Lordship, it's more than a year that I've been
We'll
in.
have it on Friday.
Okay. Yes, Friday.
In the meantime, Mr. Yuva, you try to bring out the deposition of the last witness,
Of the last
which
witness.
you don't have with you,
Yes, Your Lordship. I'll do that.
pre-made by the parties. Mrs. Maton, 27th.
Please, Your Lordship, I have a request, Your Lordship, for item number 18, Your Lordship. The senior conducting counsel, he's not well, Your Lordship. He's been hospitalized yesterday. Your Lordship, this matter can come up on Monday, Your Lordship.
Some urgency is there because I have been suspended, madam. I'm the same of Iman Husum. Some urgency is there, but because of the health, we cannot help it, madam. If
Prayer is made on behalf of the respondent, seeking accommodation on the ground that the learned senior counsel, who is in,
Mr. Kintai, Your Lordship.
he's in hospital.
Yes, Your Lordship. Yesterday. And for 123, Your Lordship.
Respondent 1, 2, 3 more. Kunung Tungau. That is it. Mr. VJK Kanta is indisposed on health ground. Receive not being objected to by the petitioner. That is adjourned. List the same on 30th. Monday.
madam.
Right.
Please, Your Lordship, I beg to mention item number 5, Lordship. This matter come after 3 weeks, Lordship.
Premier by the appellant, this is matter after 3 weeks.
That's Lordship.
Please, Your Lordship, I beg to make a mention of item number 2, if this matter may be taken up after 3 weeks, Your Lordship.
Same order. Hearing list practically gone. What else do we have? Order.
I'm for the state, my lord. Deeply obliged.
Lordship, I beg to mention item number 6, Lordship. Let this matter come after Puja vacation, Lordship. I have after Puja vacation, Lordship.
What is this matter about?
The matter is all about, Lordship, release of the gold bangles which they have seized.
You are the?
I'm the here. From me they have recovered the bangles.
You don't want it back.
No, actually, Lordship, the arguing counsel is from Delhi, so the arguing counsel will be coming after vacation, Lordship, if it's possible.
Since you are asking for time, otherwise we were about to give it to you right now.
Sure, Lordship.
On prayer made by the counsel for the respondent seeking accommodation, matter is adjourned. This is the same after 3 weeks.
Lordship, if it is possible on 14th October, Lordship, if it's because the arguing counsel is from Delhi, so if it's possible, Lordship.
14, we don't know. 14. Release it on 16 then.
Alright, Lordship. Alright.
This on 16.
Supplementary list, item number 1.
Lordship, I'm praying if this matter may come up at the end of the board.
We are already at the end of the board.
Just one more matter. I'm being led by the learned Advocate General. He's on legs before the Supreme Court.
Item number 2 may be taken up in that case first. That appeal is by the private respondent.
Item number 2. Where is item number 2?
There are 2 appeals. Supplementary list. Readable 36 and readable 38.
Oh. Okay. Supplementary?
Yes.
I think 1 and 2 are, similar.
Similar.
It emanates out of the same in order.
So in item number 2, my lord, my learned friend is for the appellant.
Of course, we have gone through that process of deletion of certain.
Yes. Those things are yes.
So we'll take up number 2 first.
Yes.
Lordship, I'll take Lordship first to the judgment. Page 30. Shall I read it, Lordship?
Please.
I have to read it as well.
Read only the relevant portion.
It starts from the brief para 2. The brief facts are that the Meghalaya Power Generation Corporation had issued a tender notice for construction of a multipurpose indoor stadium and Noktrai Village Mosundram in East Khasials for an estimated value of so and so through e-tender. on a two-bid system, technical and financial, from registered Class 1 contractors under the Meghalaya Power Generation Corporation Limited. The petitioner, along with 4 others, that is respondent number 9, 10, and 11, and one Sri Mustafa Kharkongar, participated in the bid process on 26/7/2023. When the bids were opened, it was found that the respondent number 9, 10, 11, and Sri Mustafa Kharkongar had quoted identical rates, whereas the bid of the petitioner was fractionally higher. The petitioner, thereafter being surprised that there was no system of technical evaluation represented before the respondents, and not on receiving any positive response, caused him to file further representations and letters. But however, by work order dated 15/2/24, the contract was awarded to the respondent number 9, one of the tenderers who had quoted identical rates. Being aggrieved thereby, the writ petitioners had approached this court. Lordship, the whole case before the single judge was projected that there was no technical evaluation done. Only they went straight to the financial bid, and the bid was opened accordingly. Like Lordship, it is an e-tender. In e-tender, the systems are already done. Once you go with the technical bids, if it is okay, then only it will come to the financial bid. Here, this is the way how, with lies and deception, Lordship, the single judge was influenced. Therefore, he was made to believe through the petition that it was only when the opening of the financial bid, these 4 were same bidders. They had quoted the same price, the estimated value, and he never stated in the writ petition that he was the L2 bidder. So if he's the L2 bidder, even a fraction also is higher, he's an L2 bidder. He doesn't have even locus standi to come and challenge this work order. This is my case. Like he did not have any locus to come before this honorable court, because he being L2 bidder in the technical.
Who are you?
I am the one who have been awarded the work. So in those 3 another points were taken. So I want to read this entire judgment, Lordship. Then we can come to a better conclusion. So Mr. So-and-so, assisted by so-and-so learned counsel for the petition, has submitted that selection of the respondent 9 is vitiated with arbitrariness and malafide. As firstly,
instead of reading,
Lordship,
instead of reading the whole order, so
what
it's quite a lengthy.
Lordship,
you tell us that you have told us.
I'll go straight.
You have told us the gist of the subject matter.
Lordship, what happened? First gist is that the entire matter was projected that he was also the bidder who was successful in the bidding, and without consulting him, they have these 4 were brought into a meeting whereby they decided to award the contract to my client. The whole, again I'm repeating, the whole case was made on the basis that there was no technical biddings. So Lordship, I'll go.
So the work was allotted to you.
Yes, Lordship.
So what is your grievance then?
Because the work order is cancelled by this honourable court. That is why I'm in challenge here. Yes.
My lord, sorry to interrupt. If I may make a submission, my lord, small submission.
Yes.
My lord, the current counsel, learned AG is on next. My lord, if the matter may be passed over, my lord.
In the meantime, they can make their submission. You are there. You can brief the AG when he comes.
Lordship will come to the inner page of the writ petition. Para.
Yes, madam, tell us what is technical evaluation according to you?
Technical evaluation is it is already in the memorandum of the tender.
How it has been done in this matter?
All of them qualified, even the
No, where is that? Where is the evidence that it has been done?
That's why record has to be called for.
So as this is your case, your burden is on you.
Lordship, the
burden is on you. What proof you have here to show that there was a compliance?
Yes, Lordship, I'm showing.
Just show us where it is. Where? Just show us. Where
Lordship,
this technical evaluation was
this
done.
is why I'm saying the records are very necessary, because here I don't have the official.
Until and unless you make out a case for admission, there is no question for us calling that.
Because the technical evaluation.
Show us prima facie. Where is that?
Yes, Lordship. Yes. I'm coming. Lordship, I'm coming.
Yes.
Lordship, I'm coming.
Where? On what basis you say that technical?
Lordship. Now, the first what he does, he files an application on 4th October, Annexure 3, page 94, With reference to the above, this is to bring to your notice that we had participated in the mentioned tender but could not find the evaluation criteria in the tender documents of the tender so-and-so. As per document so-and-so, the official respondent, they have answered to this one at page 96. With reference to the cited above, it may be informed herewith that the representation sent...
Go slow. Allow us to come.
Lordship, page 96. I'm sorry, Lordship.
Page?
96. This is the communication.
The reply.
The reply.
Yes.
With reference to the subject cited above, it may be informed herewith that the representation sent by your good self, white letter so-and-so, has been scrutinized by the tender committee in a meeting so-and-so. The committee has emphasized that the points raised from your end does not correlate with the financial evaluation process, as it is related to the technical evaluation in which you have already qualified. Only after they are qualified, they'll be brought to the, first the technical evaluation have to be qualified by all the tenderers. Then only it will go to the second bid, like the financial bid. This is my case. He was present on the day when the technical bids were open, Lordship. He was also present on the day when financial bids were open. Now why he because he's a meager amount difference, what he does, he keeps on writing. Now Lordship will come to page 94, this one I have replied. Then again Lordship will come to page 97, annexure 5. Again he writes, to make out a case, he writes all this representation before the government.
Was there any affidavit filed by the state in the matter?
Yes, it was filed.
What is their answer to that, about the technical?
They simply said that in technical bid everyone qualified.
Everyone qualified.
That was their stand. But our main point was that, if your Lordship will kindly come to page 99.
So they say that this technical evaluation was done.
Evaluation was done and everyone qualified. Our concern was that if you have done...
The single bench said that no technical evaluation was done.
Single bench has said...
Yes, Lordship.
No, single bench has said that the basis of... the purport of the finding is that the basis of technical evaluation has not been made public. And why technical evaluation was necessary? Because all the 4 bidders had quoted identical rates. Now, the concern that was expressed by the writ petitioner before the Honorable Court was that, since it was a case of identical bids, so naturally on the assessment of the technical competence of the person, the best one has to be selected. Now, if you have decided that 30%, assuming for a moment 30% is the benchmark, now you can say that all of you have qualified in the 30.
You are going to the details of the evaluation. Now, if that, like the single bench has had, that there was no technical evaluation at all.
No,
perhaps something else.
No, perhaps the wording, the wording of the Honorable Judge has been little other way around. But
it makes a huge difference.
No, but the purport is that, Milord, purport is, if I can read the observation of the Honorable Single Judge, the purport is that, Milord, the last time the MEPGCL had wrote to us, they said that we are looking at your, when we, after submission of these replies, when we clarified that actually what we were looking for, we were saying that if you have qualified all the persons, all right, all have qualified, but inter se, what will be their inter se position? In an assessment, you have qualified all the 4 bidders or 5 bidders. Now, despite having been qualified in the financial assessment, what is their inter se position? They are all cannot come under the same status. There will be a status variation, and that status variation will be determinative of the fact that who has got the more technical competence to be awarded with the contract. Now, when we wrote this to the MEPGCL, then if MEPGCL writes to us this letter, if your Lordship will kindly come to page 99, MEPGCL says,
Lordship.
Just a moment.
If your Lordship will kindly come to page 99, then MEPGCL writes to us, am I with your Lordship, my Lord?
Yes, yes.
In inviting a reference to the subject cited above, this is to inform you that the representation received at this end by your letter under reference number so and so is under scrutiny by the competent authority. The matter will be informed in due course about the decision of the concerned authority. And thereafter no decision comes.
Because that was not needed, Lordship, because...
No, even if it is not needed, you say to me that our decision will be communicated to you. Why is there no communication? That's why, my lord, the honorable single judges say.
And there are some certain other aspects which we have to.
Yes, we will. I'll satisfy your lordship.
This is.
We'll come back to you.
Yes.
What happened now, lordship? They have said that he never mentions that he's a L2 bidder. The moment he mentions L2 bidder, he cannot come before this writ court. He doesn't have any locus standi. Then the whole thing was processed as cartelization. According to the if it is at all cartelization, lordship, because this whole 3 bidders and one Mustafa Kharkongar, 3 bidders are from the same family. The tender doesn't have any embargo that from the same family, they cannot submit tender. There is no embargo. They are aunties, father, and the appellant, who are individual family. They have been maintaining individual family, individual business. And very interestingly, they had quoted the estimated value of the tender. These 3, along with another one, Mustafa Kharkongar, 4 of them quoted identical rates, that is the estimated value. So when he is nowhere in the scene now because he's an L2 bidder. So what the government does, they arranges a meeting among these bidders and ask them, see, we stayed for a long time, it has been just lying. We have to do it as fast as possible. You discuss among yourself. So an agreement is made and arrived at by both 4 of them. And then all of them agreed that the contract should be awarded to him, my appellant. Now,
but is that the procedure or the process to be followed?
Yes, it can be, lordship. It is the tender, the owner of the.
As Mr. Datta has pointed out, you see, there may have been, we don't know, the system of evaluation, inter se competency.
Yes, competent. All are competent. They are all first-class contractors.
Yes, but
yes,
the rankings,
lordship.
so to say.
No, ranking here, technical evaluation. They have got. It is here only, lordship. They have all qualified in. They have annexed it in their petition.
They have all. You see, they have all reached the benchmark.
Yes, they all have made it. Now, after they reach the benchmark, then he'll come to the financial bid. In financial bid, he will not be called for because he's the L2 bidder. And now they say cartelization. If at all cartelization, lordship, it is not this writ court. It is the competent competition authority who has the power to do. Because it is their own this one, lordship. I'll come, lordship, to that. Lordship will come to 163. This is a notification by the financial case. They have already stated in 157 the manual for procurement of works. In short, manual.
163?
Yes, 157 onwards.
157?
Yeah, it is their affidavit where they have put this. 157.
Here,
pagination is not visible, madam.
157.
It will be 158 perhaps.
It continues from 157. Yes,
11.
158, 12.
Para 12 or 11?
Yes, 12. 158, lordship.
Okay.
Clause 5. Evaluation of bids and award of work. The evaluation of bids is one of the most significant areas of purchase management, and the process must be transparent. All tenders are to be evaluated strictly on the basis of the terms and conditions incorporated in the tender document and those stipulated by the tenderers in the tenders. The contracting authority may include quality, price, technical merit, aesthetic and functional characteristics, environmental characteristics, running costs, cost effectiveness, after-sale service and technical assistance, delivery date and delivery period or period of completion, etc. No criteria shall be used for evaluation of tenders that cannot be verified or not stated in the contract, with the exception of provisions of laws in force. No hearsay information so and so, so and so. Yes, again, lordship will come to para 163, page 163. It discusses what is cartel formation. 163. Lordship has got it?
Internal page 16.
Internal page 16.
I think the pagination is not done properly.
Not done. Some pages it is there, some pages it is not there.
Who has filed this?
Probably they xeroxed it after paginating it.
Yeah.
Yes, in the
Yes, Lordship. Yes, Lordship. So it
that
will
will
be
be internal page 16.
16. After 163, it's prominent, I think.
My Lord's copy is perhaps a better one than me.
Discrimination.
I'm sorry, Lordship. I'm upset.
No, but the other brief is very well prepared. The government's, I mean the MEPGCL's.
Don't compare.
No, it's not a comparison. I'm saying the pages are legible there.
He's my friend.
But you see, you
I can correct it just now. Let the AG do.
You're supposed to assess the court.
Lordship.
In all respects.
Lordship. No, he's my friend.
Now,
I'll file a proper
if
copy.
my brother is finding it difficult.
Yes, Lordship. Lordship,
please.
I just can say that let the AG start. I'll just correct Lordship's copy.
You have filed this appeal.
Lordship, yes, I'll file a proper copy.
No, it's okay. You can continue. We'll see.
Lordship has got it.
Yes.
Now, cartel formation. It is possible that sometimes a group of bidders quote the same rate against a tender. Such pool cartel formation is against the basic principle of competitive bidding and defeats the very purpose of an open and competitive tendering system. Such and similar tactics to avoid control through competition in a tender leading to appreciable adverse effect on competition have been declared as an offence under the Competition Act, so and so until here. Here, we did not go with a higher price. We had put the estimated cost here, Lordship. That's why there is nothing cartelization in this case. There's no way of cartelization because we cannot bid lower than the estimated value. We bid exactly on the estimated value. Before this, Lordship, I want to make a submission before I go. The fourth bidder had also bidded the same estimated value, but very interestingly, he is not bought into this petition. In that petition, he was never made a necessary party. Instead, it was projected before the court that he is also a part of the family. Had he been bought, he would have submitted before the court. But we also, my clients also, I don't know what reason they did not come and participate in the writ petition. So I'm just making it clear before the court.
You also do not know what is the reason.
You have not made him party.
No, they were party. They did not contest the writ petition.
Oh.
Because they were of the view, I have already stated why. They have already have the view that he being a L2 bidder, there is no way of this petition standing in the court. They had that projection in their mind, so they are not before your court. So negotiations. Now, so anything, if it is here only.
Okay, now we have understood whatever you want to say before the
Lordship.
That the tender was floated. There were 5 bidders.
Yes.
4 of them has quoted identical
rates, yes.
Which is the estimated value. And 1 has quoted below or higher than that, marginally. And see, the problem is why the trial court, the single judge has found fault is with regard to the 4 bidders, rather 3, who have quoted identical price, and they have agreed among themselves to get the work allotted to one of them. So that in itself would speak of
Lordship.
If not technically,
the owner of the tender, he has full right how he decides. The Supreme Court, Apex Court, in many cases, yes,
we know.
Yes, Lordship knows it very well. Yes, Lordship. So
work need not necessarily be allotted to the lowest or highest.
Highest, yes. And also the Supreme Court makes observation in various cases. In tender, when there is no malafide, no arbitrariness, the Honorable Writ Court should not intervene in. Because they are the best one whom they know who will be the best for their work. This is the observation made by the Supreme Court.
You have to defend. You have to rather convince the court.
Yes.
As far as this 5.6.5, this page 163 is concerned, cartel formation and pool rates.
Yes, yes. That is what I'm saying.
That will be in course of hearing.
Lordship.
Yes.
Yes.
Your Lordship, kindly see page 92 of my appeal. Page 92 is a tender.
Your appeal?
My appeal, my lord. Page 92, first appeal.
But what we are on this first. Are you respondent here?
I am respondent, my lord, but because I have preferred my own appeal, my lord. Issue is common in both because judgment impugned in both the appeal is common, my lord.
You have favored them.
I have not favored anyone. My case is what they are saying. I have favored none. This is completely.
Let's not use the word favor. But you have chosen them.
What I have chosen, my lord, because I have to choose one. I have to choose one whether they come or they come. It is immaterial for me.
We are not on that. Now we understand that you are the.
I am the authority which has floated the tender.
Exactly.
Yes, I am the authority which has issued the tender. Now kindly see what is the case which has been set up by petitioner and what is my case and where the Honorable High Learned Single Judge has gone wrong in recording its finding. Because what is weighing with your lordship is that there is some cartel which has been formed and because of which the writ petitioner has been denied the right to continue with the tender or to get the tender. That is what is weighing with this Honorable Court. What my case is, my lord, is that this is a tender. That's why I wanted to show what is the tender all about. It is not a tender where I have not disclosed the minimum price. I have disclosed that everybody who is willing to participate in the tender has to quote this amount. If he is going to quote anything below that, he will be disqualified. This kind of tender is a very common tender when I know the cost of building the indoor stadium. I know the cost that anybody who is saying that he will build the stadium below this cost, either he will compromise with the quality or he will compromise with things. So this kind of tender is a standard tender where the price is quoted. Now, given a situation where price is already fixed, that this is the minimum price. Now, what happens, my lord, in these kind of tenders, then bidders know that this is the price on which you have, this is below this, if you quote, you will be disqualified. So now the competition among the bidders are there whether they have 10 rupees extra or 100 rupees extra or 1 rupees extra or same price which we have. Now if all bidders are quoting same price, that would not lead to inference that there is a cartelization. There is a cartelization because the price is quoted. Now assuming, my lord, what is the difference between the successful bidder price and the price of petitioner is 1 rupees some paisa. 1 rupees 20 paisa. Now my bid is of 100 rupees, his bid is 101 rupees. As an authority, I have invited all those who have quoted 100 rupees, saying that all of you have quoted 100 rupees. I have to choose one, and this is a public project where I have to choose one, where I have to build the indoor stadium, and his bid is 101 rupees. So his bid is higher than the bid quoted by others. If his bid is higher than the bid quoted by others, he has no right to say that no, I should also be invited because I have quoted only 1 rupees more. The principle in law is that your bid is higher than the bids of others. And what you are seeking from this court is entitlement. If you are legally entitled, then only you will be invited. Learned Single Judge, in my greatest respect, has gone wrong in construing this aspect. Is that, look, everybody has quoted one figure because that is the figure which we have mentioned. Anybody who is quoting below that figure will be disqualified. Second thing which Learned Single Judge, in my respectful submission, says that there are 3 or 4 members, additional affidavit was filed at the later stage, they belong to same family. So therefore, some of them have not, after issuance of notice, some of them have not participated before this Honorable Court or contested the matter. Your Lordship is aware that if I am not a successful bidder, I have not been awarded with the bid. Why should I come and contest? I will contest only when I have the chance of getting the bid. Otherwise, if I do not contest, the inference could not have been drawn by learned single judge that despite notice, the private respondents have not come, therefore there is a cartelization. That is not the material, in my greatest respect, to come to the conclusion that those notices have been issued to those.
The person in whose favor the tender was settled, did he enter appearance?
He did not enter into the.
He has not defended.
He did not defend.
What you say, that means it is not correct. It is not that the people, those who have, the
no,
person in whose favor settlement has been made, he also has not come forward.
That is one. That is one. And the learned single judge.
What would be your silence? Just see what would be which way the court will take.
Yes.
Silence of a litigant.
Yes. Yes. Very pertinent question. If the bid in whose favor the tender has been settled, he is not coming forward. He is seeing that the state government or the authority is defending the action. That is one aspect of the matter. Second aspect of the matter is authority is and if he is not appearing,
so state will be defending his right.
A state is defending its own action because the state is bound to have the interest in the tender where it has to have at the earliest completion.
So far as the allegation of cartelization and then the
no, and there is one more aspect.
Private respondents,
yes,
being member of one family.
Yes, my lord.
I don't think state will have any knowledge about that.
Yes, my lord. I have no. I admit.
It is not your duty.
I have no. I have no knowledge. What I say, even assuming they are members of one family, without admitting, because I have no knowledge. There is some affidavit. Assuming all of them are class 1 contractor, is there any law which says that they can't make the bid? And if they bid same price, if they make the bid of same price, it is a cartelization.
Then which way we come to
the conclusion which we have to reach conclusion in law only.
What more is needed
to
record a finding of cartelization?
Now, if the cartelization is in those cases, cartelization takes place in those cases where the price discovery is not known. Price discovery is not known. Here, price discovery is known. Price is known. If I am a class 1 contractor and my all family members are also class 1 contractor. They all submit the technical bid. Besides me, there are others also submit the technical bid. There are two consequences which your lordship will have to examine because because the state is defending its action of awarding the bid. That does not mean that state is saying that the 4 family members have participated. Therefore, this bid has become vitiated. Kindly see. That's why I wanted to show the facts so that the things will be clear, my lord. Because what has happened, I even assuming for the sake of argument in public interest also, the lordship comes to the conclusion that there is a cartelization. There is a cartelization. Ultimately, there is a cartelization where 4 family members have submitted identical bid. What is the material for your lordships to come to the conclusion for cartelization? That there are identical bids, A, B, 4 of them belong to family members. These are the two materials.
See that all of them have received notice. And in spite of the
yes, there I have with there I have
them have appeared before the court.
Yes, my lord. Yes, I have greatest respect, my lord. I have one submission to make, subject to your lordship's consideration.
You stand up here to make submission.
Yes, no. What I say is that there I beg to disagree because if your lordship would start taking the cognizance or forming the opinion that I have issued notice and they have not come before me, therefore there is a cartelization. Besides my family members, allegedly, the others have also not come, who were not successful.
Is there anything in law which allows a court to presume certain situations?
Yes, my lord. That's
it's not a criminal.
Evidence Act says Evidence Act that certain things are to be presumed. One presumption which lordship is drawing is that I have issued notice to 9 respondents. Out of 9 respondents have not appeared, including the party, the bidder, because petitioner has not pleaded him as a party to the case. One of the bidder has also not been impleaded party to the case. His writ petition should have failed on that. But before I go to that, let me place the facts so that the law and all these points can be appreciated in the light of what is going to happen, my lord. Is this that the project, whether he will get, suppose your lordship has struck down my tendering process on the ground that it is cartelization and it is not fair. His bid is higher. He is not entitled to bid. He files.
That's why single judge has not issued any direction.
And
to
so
the
yes,
ministry.
so there is no direction, my lord. If public because what has happened, this is the now I will go ahead and I will issue a fresh tender after 1 year. Again, what is going to happen? The price of construction will go up or not, because law has been laid down by this honorable court or by the honorable Supreme Court that the even assuming your lordship finds something amiss, which I vehemently submit that there is no amiss when I show the records. I have not shown the records. What is how the learned single judge has gone wrong on the issue of returning the finding on cartelization and the basis that I have to show before your lordship. My friend has not. If I show before your lordship that if your lordship finds something amiss in the process, then your lordship will weigh the public interest whether by striking down tender, whether public interest will be served or not. That is the case. That is the position of law.
Is it the sole factor? Is it not that even the writ petitioner has some right, vested right?
Writ petitioner has no vested right in.
Just in the name of public interest, can we deprive the writ petitioner of its right?
What is the? I put a question to myself. What is the right to the writ petitioner in this case? Is he a bidder?
Settlement, right to see if
No,
fair settlement process.
no. His right is that he should get the bid. He's not filing a petition in public interest. His right is that he should be awarded the contract. Is he filing a petition in public interest? I am putting a question to myself.
Not question fighting against public interest.
Yes.
Definitely. But then, do you want to say the individual doesn't have any right?
Now is in abstract, my lord, an individual has right, but your lordship will have to see the right in the facts of the case. Every individual has fundamental right. Every individual has a fundamental right, but your lordship will have to see whether there is a right in the facts of the case or not.
See, right to equal treatment. Right to be considered
Equally. Now, is he equal? I put a question. He is not equal in this case because his bid is higher. His bid is higher. He is not in same class, whereas the others are in the same class whose bid is equal. So, when I say classification, Article 14 talks about classification. When you are equal, like should be treated alike.
What about adoption of some, you see, like illegal practice, just to oust him from the zone of consideration?
Now, that is what your lordship has to decide whether there is an illegal practice or not. That has to be seen because he says your lordship will see two facts in my humble submission. One, whether he has a legal right. One, because if there is all 9 bidders, including some of the family members, all 9 bidders, not only, they have submitted identical bids. And all 9 bidders, identical bid, his bid is 1 rupee something higher. He should have also submitted the identical bid, suppose. Then in that case, whatever, if I would have ousted him, what prevented him from submitting the identical bid? Why did he, by submitting 1 rupees more or 1 rupees 20 paisa more, he will not become holier than thou? No, because ultimately your lordship is weighing the public interest. I am only concerned, as a state entity, I am concerned with the public interest. Kindly see what is the project about. What is the ramification of your lordship's order?
Mr. Kumar, I think we have understood the case. The only consideration that would, befall this court is to go into look into the process.
Yes, ma'am.
As to how the process was carried out, whether it was, as my brother said, whether it was a fair process.
Yes, ma'am.
As far as the authority of the tenderer is concerned, we know.
Yes, ma'am.
You are at liberty to choose anyone. But what was the basis?
Yes, that's why your lordship kindly. Yes, I'm grateful, my lord. I'm grateful. Kindly see page 92. Page 92. Of my appeal, my lord. Because ultimately we will bow down to whatever order is passed by your lordship, but I just want to place. Yeah, we'll show that. Facts first. Your lordship, kindly see short tender notice. The e-tender is invited in
just a moment.
I'm sorry, my lord. Page 92.
I'm just looking at the cost title.
There was some problem in the cost title earlier, which was corrected probably.
Now this corrected by hand, whatever. So what is left now? There is and there will be 4 respondents.
Yes, my lord. They were performer respondent. 2 to 8 were performer respondent.
No, now they have become 2, 3, and 4.
Yes, ma'am.
I think it was corrected by hand. We have allowed. So are they in attendance before the court?
9 for 9, Lordship.
Two,
Now it has become
2.
2. So I have, because since it has come to my notice, although notice has been not served officially, I have put my wakalat number.
What about 3 and 4? Mr. Umar?
I have a lordship. I have to find. Notices may have notices have to be served on 3 and 4. Is 3 is also chief engineer, so he was also
no, not 3. Look at the corrected.
Sorry. The 3 will be
3 would be Connie F. Sakumi
and Palinster Sok. My lord will have to check the service report on them. Service report.
How do we hear on admission then? If
Yes, my lord. So the service has to be on them. Without service,
we haven't. We should have.
Yes, my lord.
Should have taken
I'm
us through
sorry
the
for
basics first.
wasting your lordship's time.
Well, the appeal is yet to be admitted.
So notice has to.
See,
Notice
now,
has to.
When we are on admission, this is hearing on admission.
No, your lordship has already issued notice on 12th July. 12th July, your lordship has been pleased to issue notice to petitioner to take.
But then not after admission, isn't it?
No.
Does it say it is admission? You will have to admit and issue notice.
Your lordship has already issued 12th July order of your lordship. Before admission. After admission also.
Notice be issued without admitting an appeal.
Only once notice issued, or I'm not clear. I'm sorry, my lord.
No, see, if it is rate appeal, normally notice is issued only after admission. If a matter appeal is dismissed, because rate appeal is not a matter of right, isn't it?
Yes, my lord. Yes, my lord. Yes, my lord. Generally, yes,
so
rate appeal is notice issued.
There is no question.
Yes, that is the correct.
So notice is issued only after admission.
Admission, but your lordships has been pleased to issue notice on 12th July 2024.
No, this is only with regard to the deletion of certain names.
Petitioner to take a step for service of notice on the remaining respondent by registered AD within 3 days.
Have you taken steps?
That probably may have been taken. My advocate on record is stuck in court number 1, my lord. I'm sorry.
In any case, my lord, it is only for consideration of the
whether
whether the appeal will be admitted or not.
I'll follow.
You are in attendance now.
Yes. I mean.
So you have received notice.
Yes. No. I appeared on caveat.
Oh, you appeared on caveat.
My predicament is that, my lord, although I was on caveat, the caveat was not discharged, and yet there was an interim order. That is my.
Caveat has not been discharged.
No.
How can it be? Caveat has
And there is an interim order. That is my predicament. That's why.
On the day when interim order
But
was
ultimately,
passed, you were not present.
I was present. I said that I am appealing on caveat. But I asked for.
Your attendance was there. The caveat was not discharged. That is.
No, actually, 2 appeals had been listed on that day. So the second appeal was coming on as a matter of surprise to me. So I said that accommodate me for some time. I'll make a submission together. I sought adjournment. But somehow, my lord, in the order, my lord, it is not been reflected. In the second case, although that reflection is there, but in the first case, the caveat was not discharged, and yet there was an interim order. In any case, if your lordship, since your lordship is taking up matter for consideration whether the appeals are to be admitted or not, I think, my lord, that should not detain the court that the private respondents are there. Because primarily it is to be seen whether the appeal merits admission or not. That is the purpose for which it has been posted today.
Of course.
Yes.
But you see now, in the light of the order of 12th July, notice has been directed to be issued.
Still, since nobody is in appearance today, my lord, your lordship can still decide.
We still don't know. We have yet to get receive the service report. If they fail to appear, that's a different thing.
Oh, but these 2 private respondents, they did not also make any appearance in the court of first instance.
That's beside the point. There's nothing to show that steps have been taken.
Your Lordship, I'm sorry.
Yeah.
I have also prepared matters. I'm thinking.
Lordship, for admission, may I show another point, Lordship?
Right now, service first service has to be effected.
Let us be clear.
I have not finished my argument. I have not finished my argument. Please don't interrupt.
Just a moment. Oh, seriously, sir. What is this matter? See. Okay.
There is nothing to show notice has been issued, Mr. Kumar.
I'm sorry, my lord. Then we'll have to take a step. I'll seek.
Nothing. You said that notice was issued, but no notice was issued.
The petitioner to take a step to service of notice on the remaining respondent by registered AD, but the steps may not have been taken after 12 July orders. That your lordship will see paragraph 3.
Of which order?
Oh, sorry, my lord. I'm reading.
This is a single bench.
Oh, I'm sorry, my lord. Notice has not been issued. I'm sorry. I'm extremely sorry. I'm extremely sorry. Matter has to be heard, my lord, before issuance of notice. Matter has to be heard. That's why a step may not have been taken, my lord. It was a single judge order. It was not.
Till here.
Notice have not.
We forget one. Go here.
Oh. That is quoted. No. I'm sorry. Extremely sorry. I was under wrong
We are
impression.
also confused.
So I was arguing, my lord, on the admission part, my lord. Yes. Lordship, I was placing before your lordship the tender at page 92. Whether it's a fit case for issuance of notice or not.
Yes.
Page 92 I was showing before your lordship, my lord. Short tender notice. E-tender is invited in two bid system, technical and financial bid from registered class 1 contractor under MEPGSL for the work as detailed below. Construction of multi-purpose indoor stadium and Nongtrai village is Khasi Hill district. Estimated value is 2,87,89,896. So if the value is fixed and the purpose is also fixed, my lord. Now kindly see who are eligible for submitting the bid. That your lordship will find at page. Next page is 93. The details are there, my lord. Kindly see clause page 94. Technical, your lordship has found technical bid criteria at 3A. The tender must be MEPGCL registered contractor of class 1 and attested copy of registration should also be submitted along with the tender, failing which tender is liable to be rejected. Then the various requirements are there, technical requirements are there for submission of the bid by the bidders. That all the bidders are technical bids. Your lordship has to bear, in my humble submission, two facts. One, the amount estimated value of the contract is already disclosed to all bidders. That is why my friend has submitted a bid 1 rupees higher, 1 rupees 20 paisa higher. All other bids, all other persons have submitted the bid of 2 crore 87,89,896. Now, I have a situation where 9 bidders are there. Out of 9, 8 have submitted the disclosed estimated value. 1 has submitted more than estimated value. I have to choose one. I have to choose one. Ultimately, all the bidders who are having equal value, they are saying that they are giving up their right in favor of one. Whether that would amount to cartelization, my lord? Because cartelization, I will show from case laws, cartelization in those cases where the value is not disclosed and all the bidders, not the so-called relatives, etc., or members, all the bidders are associated by shareholding or by companies, etc. Here price is known. So anybody who is submitting a bid below 2 crore 87 lakh rupees, I will reject it. Anybody who is bidding lowest to 287, I will accept it. And who can submit it? All class 1 contractor. So far so good, there is no problem with the petitioner. The petitioner has not questioned the respondents or private respondents, saying that they were not technically qualified. They were all technically qualified as per. I did not find a single line in the writ petition saying that they were not technically qualified. They are all bidders. They are all from one clan, one family, one assuming for. But everybody is submitting the bid of 2 crore 87 lakh rupees. Now, what you do is you file a writ petition saying that no, there is a cartelization. Cartelization takes place when the price discovery is not known. Here, all class 1 contractor are eligible to submit the bid. Now, this, your lordship, also see 4th July 2023 is the date of the invitation, my lord. 4th July 2023, date is open, and after 4th July 2023, the work is awarded. Your lordship will notice that today I go ahead and again invite the tender. Possibly inflation, possibly higher rate, I will have to put higher estimated value. I have to put higher estimated value. So in public interest, whosoever is going to give me this constructed building, multi-purpose building in 287 is in public interest, he should get it. If my friend's client is giving 1 rupees more, why should I choose him? Why should the government authority choose him? It is his private interest versus public interest, which your lordship has to weigh. And for private interest, he can't jeopardize the public project. Now, kindly see what is his prayer. Yes. Oh, and your lordship, kindly see one more clause. 4.3. That financial bids part also at page 95. Why the allegation of cartelization in the facts of the case is not correct, my lord. Financial bids. Small Roman 3. Yes. Tender quoting below the estimated cost of the work will not be accepted. So if you quote anything below 2 crore 87 lakh rupees, that bid will be invalid because of 4.3. I visualize a situation, my lord, where
the expectation is that everyone will quote the estimated price. Then what is the purpose of calling for tender?
Yes, your lord, it's a very pertinent question, because in these kind of contracts, my lord, when this is not a contract which is there, in these kind of contract, for example, I will give one example, my lord. We invite the contract for providing security guards. We see the minimum wages, what we see the minimum wages, labor charges, everything is fixed. Then in our tender, we say that this is the minimum price on which I have got number of cases on the case laws on this aspect. The purpose is, my lord, that I have 287 is that I know the cost of construction, because you require this much amount of cement, you require this much amount of hay. Then we also factor the profit which contractor is entitled to. So there are two types of contract.
If your expectation is that the participants will quote only the rate which is just for your estimation, then what is the purpose
No,
of
my expectation.
Anyone quoting bit higher than this also will stand disqualified if we go by your.
A bit not higher, bit lower, bit lower.
No, that is what you say.
Yes, your lordship.
Supposing you are saying that the rate quoted by the respondent here.
Yes, my lord, is bit
higher
than the other
so
bidders.
He doesn't have any right. That is what you are saying.
No, what I am saying is that his bid is higher than the bids quoted by others.
So the rate
Even if 1 rupee.
Rate means the rate is not the sole criteria for selection.
A rate is the sole criteria because
you
what
come to financial bid only after a person
is technically qualified. Yes, my lord. Now, my friend has not argued that the bid of successful bidder he was not technically qualified. It is not his case that he was not technically qualified. It is not his case that others were not technically qualified.
But if there is a contention that no technical evaluation was done.
No, where is your lordship technical? What they say that their whole case is that there is a. Kindly see the writ petition, my lord.
That is see the finding of the single.
I will show that process also. I will show, because I have to show what is the writ, and what basis finding has been given, whether finding has correlation with the pleading or not. If finding has been given without material, my lord, your lordship will surely interfere.
Yes, I think what my brother says. Yes, there are quite a number of issues to be decided here.
This would require examination, my lord, because we come across similar tenders where we give the estimated value. In those estimated value, assuming tomorrow again, we have no issue. If the tender is scrapped also, fresh tender is also floated, we will give estimated value and all the parties are going to give the same value. And then we have to choose one. What is the process we should follow in choosing one? Because that principle, if once settled here, will apply in all such cases by this court. Because this is very small tender, but ultimately principles are for similar tenders will have ramification for in future also. So,
yes, Mr. Datta.
I think lordship will be rising now.
We'll
meet and then we'll fix for that for here.
Oh no,
your caveat will discharge.
But then to oppose the, continuation of the interim order, my lord, I'll have to make my submission.
Passed in his favor. No order has been passed in his favor.
Interim order was passed in your presence. There may be what technically that caveat was not discharged, but then the fact remains that you were given an opportunity.
No, I prayed for time. If your lordship will receive the order sheet in the second case, my lord, there it is reflected that I prayed for time. But somehow that has been missed out in the first order sheet.
Your lordship, that he has not moved any. This is all oral.
I'm not saying anything, my lord.
Whatever the case may be, you see what is the import of the interim order?
No, my lord.
It just specify that in public interest, so to say, the work will continue, but will be subject to the
risk and cost. Yes, now, my lord, as on date, my lord, I understand.
And even assuming your lordship will dismiss, I'm sorry. I'm sorry, I was just placing one situation which in his favor only. What I say is that a writ appeal is dismissed. The remedy will be I will have to float French tender. That is my.
We are not going too far.
So today, my lord, today I understand that my role is limited only to the aspect of your lordship's consideration whether or not the appeal is to be admitted.
Exactly.
That is my limited role, because interim order, my lord, as far as the time has flown, my lord, I am not going into that. Now the basic focus of the writ appellants in the case are principally on two aspects.
There are several other aspects also. I have not concluded my argument.
Please, Mr. Kumar.
Yes. I'm sorry, my lord. What my friend says that I have I have got several aspects to argue.
Yes, you're senior enough to understand it.
I'm taking seat.
Broadly, these centers around two aspects, my lord. Namely, the first aspect is that there is a price fixed, and since there is a price fixed and the private respondents have quoted tender on the fixed price, so the element of cartelization is unwarranted. The finding as to cartelization is unwarranted. This is one aspect. Second aspect of the matter is that since my price is though it is fractionally 1 rupee 20 paisa higher than the accepted price. So I come to the slot of L2 tender and I am not entitled to question the award of contract. As a tangent to this, my lord, as a tangent to this, the third aspect comes that merely because the persons concerned, the private respondents are belonging to the same family and quoting the identical rate on the basis of the quoted value, so the finding of this thing is unwarranted. And the technical aspect of the matter, I am making my submission, my lord, understanding the two appeals, I mean the broadly two appeals, my lord, I am trying to concentrate my argument on that. Saying that the technical, so far as the finding of the learned single judge is concerned on the technical aspect of evaluation, that is wrong because there was a technical evaluation where each one of the tenders had qualified. So these, I mean the focus is on these two primarily. There are other aspects. Now, before the other aspects are argued, my lord, I am limiting my reply on these two aspects. What is this tender? This tender was a two-bid system tender where there will be a price consideration and there will be a technical consideration. Now, technical consideration comes first. My learned friend has said that in my writ petition there is not a single statement where I have said that the private respondents are not technically qualified. Your lordship has noticed, I can show it again from the records, my lord. Right from day one, my lord, I am insisting upon them that your tender documents do not disclose as to on what parameters the technical evaluation will be done. Disclose that evaluation, technical evaluation of the tender. The parameters of technical, they keep...
The stipulations are there.
No, stipulations are there. The basis of assessment. If you are taking an assessment, then there has to be a parameter that on these parameters I am assessing the bidders. That is not disclosed in the tender. Therefore, I filed representation prior to filing of the writ petition saying that disclose this. Initially, they try to avoid it by saying that you have also qualified, so there cannot be any complaint or quarrel on this point. But at a later point of time, they write a letter to me saying that your points are under consideration of a competent authority and it will be communicated to you in due course of time. But before that due course of time could arise, they issue the work order. Therefore, my grievance vis-a-vis the aspect of technical assessment that remained unanswered. So in such a situation, how do I make a statement that he is not technically qualified or I am better qualified? Naturally, that question cannot be urged in the writ petition. In the writ petition, I said that technical assessment has not been done because they have not answered my queries. So I say that it has not been done in a proper manner. And more so when you are assessing, when you are awarding contract in respect of a particular party, considering the fact that 3 or 4 of them have quoted identical rate, the determinative issue becomes the technical assessment. Because since we have quoted equal rate, so whoever is technically more competent, that person should be awarded the contract. The benchmark you have set that this is the benchmark for qualification. Let us assume for an argument that the benchmark is 30%.
But don't you think, Mr. Datta, that contention would be only amongst them, not as far as we are concerned?
No, it will come, my lord. It will come because if, yes, your lordship is right, because since my tender is 1 rupee 20 paisa more, so that particular technical aspect of technical assessment has to be gone into only at the instance of those parties who had quoted identical rate. That is absolutely correct, my lord. But why I am saying this, the reason for saying this is that kindly see how they have awarded the award, awarded the contract. You are saying, if you say that no, these are the 4 equally competent persons available, and he has said, my learned friend has said that he has a right to choose. Nobody questions that right. But whether you have exercised your right of choice in a due and diligent manner. Now, there are 4 equally competent people before you, and you are allowing the parties to decide as to who should be awarded contract. How is it permissible in the domain of award of contract?
Something only concerns them. Which way you are affected by that?
Now, that brings us to the question of bidding on the estimated price. If your lordship will kindly come to page 96 of the writ appeal preferred by the MBPGCL.
96.
Yes, page 96 of the writ appeal preferred by MEPGCL. Now your lordship will kindly come down to clause 20.
Yes.
Clause 20 says the price bid for the works shall remain valid for acceptance for a period of 90 days from the date of opening of bids. If any bidder withdraws his bid before the said period or issuance of letter of acceptance whichever is earlier, or makes any modification in the terms and conditions which are not acceptable to the department, then the bidder shall not be allowed to participate in the rebidding process of the work. So the bid that you offer remains valid for a period of 90 days from the date of its opening. Now, just in tune with this, your lordship will also find an undertaking given by the bidders, that your lordship will find at page 104.
Yes.
Page 104, second paragraph. Has your lordship
yes.
got it? Yes. We agree to keep the tender open for 90 days from the date of submission thereof and not to make any modifications in its terms and conditions. That means the bid that you are offering, it remains valid for a period of 90 days. Now the question arises, why it is a period of why there is a period of validity fixed? Because they wanted to, the employer wanted to ensure that the aspect of price escalation is not taken an advantage by the bidders, so that after within a period of 90 days, I cannot say that now the prices have gone up, so I'll increase it. It also operates reversely. Here on the facts of the case, my lord, your lordship will find, although the bids were submitted long time back in the month of July, the last year July, they have awarded the contract this year February, much after the period of 90 days was over. Now, this aspect of price escalation operates reversely, that I will show. Now, if you are accepting as on date the price of 287, then it has to be understood that this is a bid which is undervalued, because naturally, my lord, in market there will be, every time there will be a price escalation. Prices are not static. So, you submitted a price which is in the year July 2023, and on the rates offered in the year 2023, you are allotting the work at the year 2024. That means the bid, taking into the aspect of price escalation into consideration, that means the bids offered by them are undervalued. Now, one submission has come at the very beginning that prices are fixed and prices are notified. This becomes very crucial. The aspect of technical evaluation becomes very crucial, because this is an item rate contract which the learned single judges.
Mr. Datta, in all this, it would be incumbent, or rather it would be upon the head of the successful tenderer to accept the price as quoted. If there is an escalation of price in the process or in the meantime, he will bear that. He'll have to.
No, my lord, since
of course, subject to the law or the process or the rules, which is otherwise as far as escalation of price is concerned. But see, prima facie, what happens is, if that is the quoted price, irrespective of that time period that you're saying, if it has crossed over that 90 days period, and in the meantime prices have changed in the market, he will still have to accept that.
No, I am not on the acceptance of it. I am on the aspect of, you are saying that I am disclosing the price because I know what will be the cost. I do not want somebody to, because one of the conditions in the tender, my learned friend has shown to your lordships, that any paisa, a single paisa beyond the estimated quoted price will not be accepted. Why? Because then there will be a chance of using low quality material, low quality products, and that will sabotage the interest of the public, because the good construction will not come out. Now, by the scheme that you have operated here, you are allowing an undervalued bid to go into, irrespective of the fact that you have notified in your tender conditions that it will remain valid, the bid value will remain valid for 90 days. And on the top of everything, my lord, which the learned single judge has very poignantly, my lord, taken note of, this is an item rate contract, meaning thereby for each item the bidders are required to provide rates. Now, if for the construction of a building I am to provide rates, naturally there will be variety of items, variety of materials that I will be using. How on earth can it be possible that all the bidders, all the 4 bidders, so to say the successful bidders, they are without any meeting of mind quoting exactly the same rate? I may be purchasing a nut bolt at a price of 1 rupee, you may be purchasing the nut bolt at a price of 1 rupee 20 paisa. How at the end of the calculation, each of the 4 bidders can reach the exactly same price? That's why, my lord,
you are imputing again the issue of cartelization.
No, because my lord, it has been taken a ground that the funding of the learned single judge on this aspect is wrong. That's why, my lord, I am addressing your lordship on this. How on this, my lord, without any meeting of mind, there can be exact?
I think we have heard the parties. We'll admit the appeal.
Now, my lord, may I address your lordship on another aspect?
We'll hear the matter.
I have not
Let since we are convinced that both sides, have a case.
Yes, ma'am.
We'll hear the matter ultimately.
Yes, ma'am.
Because since there are other respondents for which he has to.
Well, those respondents, I do not think, my lord, that they stand a chance
Until
because
again they will say cartelization.
Until unless he says that they have to be struck off.
Your lordship has notice has to go. Otherwise, the blame will come that they are part of my cartel only. They will say cartel. Then again, I'm caught between deep sea and devil. Deep sea.
We are trying to trip him, but then.
And my friends' bills of quantity exceeded by 1 rupees 20 paisa. All of them.
1 rupee. That's very technical in nature. What is 1 rupee? Tell me.
That too in the context of 2 crores 89 lakhs, my lord, what is 1 rupee 20 paisa? You are taking a very hyper technical approach.
Exactly.
You are taking
Lordship, may I just submit? Lordship will admit it, I know. But if I'm talking about money and all, the thing is this: they wanted to know about the technical evaluation of the bid after the opening of the tender. They should have come while before filing.
There is no requirement in law. There is no requirement in law that we should reply. Okay, we'll argue our matter, my lord. We will place our case to search.
Mr. Kumar, senior counsel, appearing for the appellant. Also heard Mr. S. Datta, senior counsel, appearing for the respondent number 1. It is the submission of the learned senior counsel for the respondent number 1 that a caveat has been filed in this matter. Accordingly, in view of the appearance of the said respondent, caveat is hereby discharged. Mr. Kumar, learned counsel for the appellant, has submitted that he may be allowed to take steps for issuance of notice upon the respondent's number 2, 3 and 4. What about 2? Are you accepting notice on behalf of 2?
Lordship, yes. I have already filed also my account.
No, here, as far as his case is concerned, respondent 2 is also represented by Ms. Accordingly, let steps be taken for issuance of notice upon respondent number 3 and 4 respectively. Same returnable within 2 weeks. There's no need to reiterate the interim order because
that is there.
Always there.
Let it be like that.
3, 9, 10.
This is matter thereafter. Who are your respondents here?
Your
Miss.
What is your name?
No.
Wait.
Yes, tell me, who are your respondents here? No, you are we are talking about your appeal now.
Your appeal.
Lordship.
What's your cost title?
इसको कर लेते हैं 28 तो
Lordship,
So, Mr. Datta, you are also accepting notice as far as
yes,
the case is concerned?
Yes. I think, my lord, so far as her appeal is concerned, my lord, I mean, there is no necessity of causing further notice because parties are here.
Exactly.
But so far as the MEPGCL's appeal is concerned, there are 2 pro forma respondents that your lordship will consider whether to issue notice or not. They are pro forma by any means.
Pro forma respondent.
They are pro forma parties.
If they choose to contest, then they become regular respondents.
Yes.
So we'll see. Heard Mr. Counsel for the appellant.
Because Monday I will have something.
On consideration of the submission made, the appeal is submitted. As far as
26,
notice is concerned, as far as issuance of notice is concerned, the respondent number 1 has accepted notice through who's your
From Mr. Lahiri, I Lahiri.
through Mr. Lahiri, Learned Counsel, led by Mr. Stetta, Learned Senior Counsel. As for respondent 2, 3, 4, 5, 6, 7, 8, and 9 is concerned, Mr. Pandey has accepted notice on their behalf. As such, no further notice is required to be issued upon such respondents. On pre-meet with the parties, list this matter after 2 weeks.
Can it be on 25th of October? Well, my friend is also coming from outside, so am I.
This is matter on 25th.
I'm there. I've got wrong tag. No.
25th.
25th.
Both case.
25th of October. Obliged.
Daily list, item number 1.
May it please your lordships. Your lordships, we were supposed to file a reply to the affidavit in objection, your lordship. Your lordship, we kindly pray for just one more week time.
This matter is about?
My lord,
With appeal, your lordship.
Vitellans.
they are not submitting, they are only delaying the process.
No, just what is the case about?
This is a single bench, engaged in single bench judge. This is a, I said that the appeal
What is the
barred.
subject matter of the case?
Subject matter is appeal. This is a seizure case, paternal seizure case.
Oh, Bettelnut, that's what I was saying.
Paternal seizure case. They have confiscated, and thereafter it was destroyed. The goods were destroyed during the pre-trial stage without permission from the appellate court where the matter was pending, and without notice to the petitioner. So, honorable single judge.
Their contention is that because they are perishable goods, so they have to be destroyed. But you are saying otherwise.
Yeah, I am saying I am contesting.
But why is it necessary to file a response?
Your lordship, actually, we've already sent it to the department for signature. We are supposed to get it back by tomorrow. Day after, your lordship, we will file it.
It's just they are.
It's an issue of law to be decided.
This is already 7 years old case. But now it was seized in 29/10/2017, and they are delaying the matter. It has reached finality by the Supreme Court also. And it is barred by monetary limit.
Yes, we have.
And this instruction.
See, you will file the reply immediately on next date.
Yes, your lordship.
Failing which, see, because there's the previous order would say that the admission will be subject to filing of the reply.
Yes, your
Which you
lordship.
have not done so. If you fail to do so, then your appeal will be admitted, will be dismissed.
Yes, your lordship.
Monday.
Your lordships, Monday, your lordships.
Much obliged.
Mr. Director Counsel for the appellant, Union of India, has submitted that the reply oblique response to the affidavit filed by the respondent could not be filed today, as specific instructions has not yet been received. However, it is prayed that definitely by the next date fixed, the same will be filed. On pre-meet, same is allowed. This is matter on 30th.
Much obliged.
So single bench will sit at 2.
Item number 19.
Please, Your Lordship. Lordship, this is an appeal against award passed by MECT. Fairly simple matter, my Lord. There are just 3 or 4 broad grounds of appeal. One is our stand that negligence was not proved through the evidence. Number 2, the fact that the driving license of the driver was a defective license. That aspect was not considered by the learned MECT. But more than anything else, my Lord, are 2 technical grounds, and what we are stressing on more is the fact that there is apparently, on the face of it, some calculation errors in the award itself, my Lord. One error was that the deductions for personal expenses was wrongly calculated. Instead of taking 1/4, instead of deducting 1/4 towards personal expenses, learned tribunal deducted 1/5. That led to some difference in the award. And finally, my Lord, the rate of interest which was applied in our submission was slightly on the higher side. It should have been a less rate of interest. So fairly simple.
What was the rate of interest?
9%, my Lord. 9%. Lordship, in some judgments has himself corrected that to 6%. But also just to inform this honourable court, my Lord, I've spoken to Mr. Nongkla also. We are attempting to settle this matter outside the court, my Lord, because we are, as I said, we are more focused on the amounts, not really on the other aspects. So if there is some give and take between the parties, matter can be settled. Some time may be given to us.
Why it was not referred to Lok Adalat?
Because we filed it after the Lok Adalat. Lok Adalat was on a Saturday. We filed this on a Monday. We couldn't make that Lok Adalat deadline, my Lord.
So what do we do?
Lordship can record the fact that respondent 1 has appeared, and 2 weeks time may be given.
I will file while Vakaladama, Lordship. I have not filed, I will file. Within this week, Lordship.
Heard, Mr. As General Learned Counsel for the appellant, who has submitted that this appeal has been filed in being the appellant being dissatisfied and aggrieved with the judgment and order dated 21/6/2024 passed by the learned member MECT Shillong in MSc case number 11 of 2015. You are appearing for all the respondents?
Respondent number 1.
There are 3 respondents. We've given copies to the counsel appearing for 2 and 3 also, my Lord. Unfortunately, he's not here today, but I'll inform him, my Lord.
So you have to take steps.
Very well take steps.
Mr. Ichnaklau, the counsel has submitted that he may be that he will be representing the respondent number 1 and has prayed for some time to file the necessary power. As such, no formal notice is required to be issued upon the said respondent. As far as respondent number 2 and 3 are concerned, Mr. Jindal has submitted that he may be allowed to take steps for issuance of notice upon such respondents. Allowed. This matter after 2 weeks.
Obliged.
Item number 20.
Excuse me.
Lordship, the applicant is before your with the prayer to extend another 60 days to pay the cost of 20,000 imposed in contempt case 65 of 2022. As a genuine reason is cited, he has taken up the matter with the council to file SLP in Supreme Court, but in due course of time his mother was not well. So we have to rush to his hometown in Akola, take care of his mother and do the needful for her medical treatment. So humble prayer is to extend for another 60 days, and in the meantime the applicant will take necessary steps to pay the cost also.
My lord, kindly see, in the name of extension, my lord, he is seeking some time to file an SLP. Earlier also, your lordship was granted time, my lord.
No,
Exactly, that is his prayer.
No, Your Honor,
Seeking time to file the
yes, he
SLP.
handed everything to the council
But
over there.
is
but
that permissible, my lord? Simply saying that, please give me some time to deposit the money, that's one thing, my lord. But to say that, give me some time to file an appeal or SLP, but that's...
Okay, pause.
Even that was, if lordship kindly sees the last order, my lord, part 12, lordship, page 22.
Each?
22, my lord.
Yes.
My lord, lordship is granted extension of 60 days, my lord. But the last paragraph, lordship says, as for the prayer of the application to keep in abeyance the operation of the said order dated so and so, to allow him to file a special leave petition before the Honorable Supreme Court, this court would opine that it is the liberty of the applicant to approach any court or any higher court for the matter. There is no question of stay of the operation of the said order dated at this point in time unless the same is stayed by the higher court. So, my lord, their intention, we do not know, my lord, what is the intention. It doesn't appear to be very bona fide. But lordship may grant another 60 days time, my lord, but only to deposit the amount. If they don't deposit,
What miss?
Counter contempt, my lord. This was order passed in contempt, my lord.
By the counsel by the applicant was submitted that this application has been filed, seeking further time to allow the applicant to comply with this court's order dated 18/6/2024, passed in contempt contempt case C number 65 of 2022. In view of the fact that in the meantime the mother of the applicant has to be the applicant was admitted Sahara, admitted at the Sahara Hospital Critical Care Center at Akola, Maharashtra for treatment of her ailment, and as such the applicant having to take care of her has not been able to comply with the order of this court. It is paid that an additional 60 days time may be allowed for the petitioner, for the applicant to take necessary steps in this matter. As prayed for, on consideration of the submission made, the prayer is allowed. The applicant is hereby granted a further period of 60 days time to comply with the order aforesaid. After due compliance, a report may be filed before this court, whereupon this petition will be finally disposed of.
Item number 21.
May it please your lordship. My lord, as per the last order, we have gone to the IO, my lord, once again, and this is the document, my lord, where his signature and the bail bond was furnished to him, my lord. If my lord may kindly see, peruse the last page of the order, my lord.
he has handwritten, the IO has handwritten, my lord, that as per the order of the Honorable Court, I have appeared before the IO.
Yes, Miss. Tell me.
Well, first of all, apologies for appearing from a cab because I'm on my way. I'm supposed to deliver a lecture at Nalsar tomorrow. That's the only reason I couldn't be there physically. The latest status report has come. It's dated 21st of September. Again, the IO states the same thing. It's the first time that the accused has appeared physically, and the bail bond, etc. It's mentioned on the second page on top. On 17th September, Shri so-and-so has appeared.
Yes.
But as Madam had noted in the last order that this would have no bearing on the merits of the case, which will be decided separately.
So now, my lord, the hurdle that I was appearing or not appearing, my lord, that has been solved now. I have appeared. They have acknowledged my appearance.
Well, there was no hurdle. It was a false statement being made previously that he
My
had
lord,
appeared when he had.
if I've gone for the second time, I was there also on the first time, my lord, but that is keeping aside, my lord. Now coming to the merits as per the order of this Honorable Court, my lord, we'll argue on the merit of the case, my lord. My lord, may kindly see Annexure 2 of my petition. This is on page 31, my lord. Page 31, Annexure 2 in series, my lord. This is general power of attorney which was given to me, my lord. Page 31, my lord.
Yes.
My lord. Exequent, my lord, is the complainant who has lodged the FIR against of me, and I am the power of attorney holder, my lord. As per this power of attorney holder, if my lord may kindly produce page 33, my lord, the next page.
Yes.
Serial number 3, my lord, I would just like to read this, that before depositing or indemnifying for any spirit to be deposited or kept under the license condition, he shall execute a bond in favor of the Commissioner of Excise, Meghalaya, for the payment of the duty at the rate imposed under Section 21 of the Act on all foreign liquors and spirit imported, transported, all foreign liquors and deposited or kept by him to the said warehouse, my lord. This by which, my lord, all the power was given to me, my lord. By this power of attorney, all the power was given to me to run the show, my lord. Subsequently, what happened, my lord? A deed of agreement was signed between the complainant and the petitioner here, my lord. That is on page 41, my lord. Page 41, deed of agreement. If my lord may kindly produce. And the deed of agreement was registered, my lord, before the sub-registrar. Again, my lord, it is a complainant. This agreement is made at Tura this first day of February 2004 between Srimati So-and-so and Gopal Kishan Gaur, who is the petitioner, my lord. My lord, the relevant page will be the page 43.
Yes.
Serial number 2, my lord. The first party has already applied for changing the name of the bond from so-and-so to so-and-so warehouse. The second party has already deposited a sum of 1,20,000 rupees. That means me, my lord. I have deposited 1,20,000. Being the license renewal fees for the year 2003-2004, white TC number so-and-so, so-and-so, this money has been paid by the second party. On and from 1st February 2004, the second party will be in complete charge and control of her bonded warehouse and manage the entire business on his own without let or hindrance from the first party by investigating his own money or money in purchasing and storage of IMFL by engaging staff of various aspects of the business by paying their rent, electric bill, telephone bill, etc. That means, my lord, it is my investment. All was my investment, my lord. Now, my lord, may kindly produce clause 4, my lord. The second party will not strictly in accordance with the condition of the license for the bonded warehouse and also in compliance with the direction or orders that may be issued by officer of the excise department of the government of Meghalaya. So, my lord, whenever there is a direction or a challan is issued, my lord, I have to pay the revenue, my lord, licensing fees, my lord. Without licensing fees, my lord, every year in the month of March, my lord, the licensing fees we have to give, my lord. Then only the license is renewed. Then only I can operate my warehouse, my lord. Now, my lord, we kindly produce the revocation that is on page 45, my lord, annexure 3. This agreement was revoked, my lord. This agreement, all this power of attorney and agreement was revoked, and my lord, some other person was engaged in my place, my lord. Now, my lord, thereafter an NOC was issued, saying, my lord, that there is no claim against of me. That is on page 48, my lord. To whomsoever it may concern. This to certify that Sri Gopal Kishan Gaur has no liabilities or dues toward a business that is Mrs. So-and-so warehouse officially released from all his duty. That means, my lord, there was no dues against of me. They made we sit together, my lord, across the table, and what was give and take, my lord, we have done, and then this certificate was issued that there was no liability against of me. Now, my lord, then there was an agreement, my lord, I have signed. I even in the agreement, my lord, which has been signed by me, my lord, has been notarized in Tura, my lord, that if there a due comes up, my lord, which may not be foreseen, my lord, in future, if there is a due between that period that where I was running the warehouse, my lord, I am ready to pay. And if till today, my lord, I, on being instructed, my lord, I am submitting. Even if till today, my lord, that there is some sort of dues, government dues or hard dues, anything's cropped up, my lord, legally, we are ready to pay, my lord. That I am undertaking on behalf of the petitioner, my lord. I have been instructed to give the submission, my lord. Now, my lord, thereafter, my lord, what happened? This NOC was issued, my lord, and agreement was made, my lord, between the other party and the complainant. Then, my lord, deed of agreement was given by me on 6/10/2021. That is on page 51, my lord. So, para 6, if my lord may kindly see para 6. Whereas it has been expressly agreed between both the parties that in future, if any pending dues, tax, loan, other financial transaction which is due against the above named IMFL bonded warehouse during the business transaction operation of the second party, that is from February 2004 till 31st day of August 2021, if any thereof shall be exclusively bonded paid by the second party and in no way by the present operator of the business, that is so and so Kishore Sharma. This is a new person who has been put in my place. Shall be liable for the pending dues, tax, transaction, etc. from the period above mentioned. Now, this is the agreement that I have swear, or I have given an agreement that if any things cropped up, please, I am ready to pay. Just inform me. Now, my lord, subsequently what happened? Another deed of agreement, my lord, was signed between Gopal Kishan Gaur, my lord, and the complainant. Another agreement was signed that yes, I am ready to pay. Then, my lord, an FIR came up, my lord. FIR after a period of 1.5 years, my lord, an FIR was filed against of me. That is on page 56, my lord. We will come back. An FIR was lodged, my lord. The FIR says, my lord, the second paragraph, in the year 2021, September month, he handed over the control of the warehouse to me, stating that all government dues are clears and the remaining stock is in the godown. However, later I learned that the excise duty amounting to crores of rupees is due to the government and the godown was empty, my lord. This is very, very important, my lord, that there are crores of rupees which was pending and I am supposed to pay. And the godown was empty, my lord. Now, my lord, may kindly come to page 54, my lord, first, before I take, my lord, to the stock of the warehouse, my lord. Page 54, this is the non-judicial form, my lord, where both the parties' name are reflected, the complainant and Gopal Kishan Gaur, who is the petitioner, my lord. Now, my lord, if my lord may kindly read page 55, my lord, fifth paragraph, my lord.
Yes.
And whereas the second party is no longer in a position to run the said business due to other preoccupation and his own business elsewhere, hence, after the expiry of the said aforesaid agreement, he has handed over all the said business in a good and serviceable condition back to the first party, who has also cleared all his dues and liabilities towards the said business on payment of the remaining sum as had been agreed upon by both the parties, my lord, receipt of which has been acknowledged by the first party in the separate sheet. And whereas the first party accordingly released the second party from all dealing with the said business, and the first party further declared that she will have no future claim whatsoever from the second party in connection with the said business in future. Well, this was the agreement which was made between me and the complainant. Even then, my lord, an FIR was lodged, saying that crores of rupees, my lord, they are not sure how much amount of money. If it is a government dues, my lord, definitely it would have been in black and white, my lord, and the amount should have been inserted. Till date, my lord, on being instructed, I am saying that if there is a due, my lord, I am ready to pay. That can be recorded, my lord, that on being instructed by the client, my lord, I am submitting that if there is a government due or any other due, legal dues, my lord, I am ready to pay. But they are not willing to, my lord, let me know how much is the due. Even if my lord may kindly see, produce the FIR copy, nothing has been mentioned. Forwarding report, nothing has been mentioned. Otherwise, my lord, definitely, my lord, if they have received any kind of receipt from the excise department that this is the amount that you need to pay, Gopal Kishan Gaur has misappropriated money or not deposited that money, that should have been reflected, my lord. That has not been reflected till date, my lord. And nothing has been informed to me. And it is blatant lie, my lord, that they have tried to contact me. When, my lord, I came to know about this case, my lord, it was me who has applied a certified copy and all, my lord, and I'm before this honorable court, my lord. Now, my lord, she says that the entire warehouse, bonded warehouse, my lord, was empty. My lord may kindly produce page 60, my lord, as I have taken my lord last time also, and it's just 12 in series, my lord. This is new registered monthly stock statement of so-and-so warehouse for the month of August 2021, my lord. On the month of August, this much was there, my lord. September, the stock is there. November, the stock is there. Now, how come, my lord, do you say that the entire warehouse was empty, my lord? That appears to be something else, my lord. So, I'm praying before this honorable court, my lord. My bail may be made absolute, my lord. And I'm ready to cooperate with the investigation. And also undertake before this honorable court, my lord, if any government dues are pending, my lord, I'm ready to pay. I will reply to my friend if she has any.
Madam, the investigation is still going on. These documents are yet to be verified. The only document that the IO had received from the complainant was the deed of agreement dated 6th of October 2023, where he has agreed to pay whatever dues may arise in future. So that's the only document that was provided by the complainant. Rest of these documents, now when he has appeared before the IO, or when his friend had appeared before the IO, those documents have been supplied only now. And we are talking crores of rupees, and this is a matter of investigation, and the conduct of the accused has not really warranted much confidence so far. So our only fear is that if he does not cooperate in the investigation, the matter, it's a serious issue involving crores of rupees. And since there is a agreement, which is an admitted piece of document dated 6th October 2023, where he has agreed to pay that amount. And if my lord may come to page 58, which is the inquiry report. This is during inquiry, second paragraph. Yes. During inquiry, self-examined the complainant, Srimati so-and-so, in the presence of so-and-so, and she stated that she had appointed Shri so-and-so as a manager in her bonded warehouse in February 2004, and since then, he controlled and looked after the warehouse affairs under his full control. But in the month of September 2021, he handed over the warehouse, stating that all the dues were clear and the remaining stock was in the godown. But to her surprise, she found that the godown was empty and also learned that excise duty amounting to crores of rupees is due to the government, as the said person had cheated her and misappropriated all the money and transferred a huge amount of money to his account as well as to his relative's account, and even he forged her signature. Further, she stated that on 6th October 2023, the aforesaid person, along with his family members, came to the residence of the complainant and admitted his guilt, and also made agreement in the presence of witnesses where he had agreed and promised to pay the due tax for the government. During inquiry, the complainant produced copy of deed of agreement which is made between the complainant herself and Shri so-and-so on 6th October 2023, but the said person did not comply with the agreement, as till date he has not paid the due tax nor any response from his side. Therefore, I would like to request you to kindly register a cognizable case against the above noted person under appropriate section of law. The case is found to be true and genuine in nature. So this is the inquiry report, my lord, based on which the FIR got registered. And the second aspect where he's saying that he's willing to make the deposit of whatever the complainant has not been made a party in these proceedings, my lord, in the bail application. So therefore, one is not in a position to make any comment on that.
Yes.
My lord, two things which has cropped up from my learned friend's submission. One thing is about the agreement that is on page 54, my lord. If my lord may kindly produce again, my lord, page 55. The daughter has signed the agreement. The daughter, if my lord may kindly produce in the right hand side of the agreement, my lord, the daughter has signed. This is the daughter who is the witness, my lord, and the complainant, my lord. And I undertake that we will pay the dues if anything crops up, my lord. Even my learned friend will not be in a position to say how much money we are supposed to pay, my lord. If they said, yes, black and white, this is the amount you have to pay, we are paying it, my lord. Second thing, my lord, her apprehension that we will not cooperate, my lord, doesn't hold much water, my lord, because we have given a bail bond that whenever it is required, my lord, we have to appear, my lord. And if required, my lord, again we will furnish a fresh bail bond also, my lord, before the IO.
Also, the original documents have not been produced so far, just for the knowledge.
My lord, if the
that is for the IO to decide. He has to take a call on that.
Yes, my lord. Whenever it is required,
my lord, he's requested for. If my lord may see the status report, it's mentioned further directed him to produce the original documents relating it to this instant case within 10 days.
Fine. Mr. SD, learned counsel for the petitioner, who has submitted that in compliance with this court's order dated 16/9/2024, the petitioner has presented himself before the IO whereupon he was made to execute a bail bond The IO has also acknowledged his appearance and has indicated as such in his note dated 17/9/2024, wherein he has stated that the petitioner has appeared before him on 17/9/2024 at 5:30 p.m. It is the further submission of the learned counsel for the petitioner that the facts of this case is that the petitioner and the complainant who has filed the FIR, who has the FIR?
Page 56, my lord. FIR dated 7/3/2024, my lord.
Filed the FIR dated 7/3/2024. inter alia, alleging inter alia that the petitioner had misappropriated money which is due to her and also has failed to pay rates and taxes as required in respect of the bonded warehouse which was run by the complainant, and as such has committed an offence under the relevant provision of law. The said FIR was accordingly registered as, where is the
RIML PS case number?
RIML PS case number
25 in bracket 5 of 2024.
under section 406/417/420/465 IPC. The learned counsel would further submit that, would again submit that the relationship between the petitioner and the complainant is with regard to the said bonded warehouse known as Mrs. Gloria Bonded Warehouse, wherein by relevant power of attorney and also an agreement between the parties, he was allowed to be he was allowed to take charge and run the said warehouse, bonded warehouse, and to give an account to the complainant, who is the owner of the same. However, in the year, in the month of September 2021, September, isn't it?
Yes, my lord.
The arrangement, agreement, and relationship between the two has been severed, was severed, inasmuch as the petitioner, with the knowledge of the owner of the said bonded warehouse, has agreed that he would hand it over charge of the said bonded warehouse to her, and in the process all dues, payments, etc. that ought to have been paid by him has been complied with. In fact, the petitioner has also executed another agreement dated 1st November 2023 to say in effect that since he is no longer in a position to run the business, after the expiry of the said agreement, he had handed over the business to the first party, to the complainant, and that he has also cleared all the dues and liabilities towards the business. Which was also acknowledged by the this complainant. However, to his surprise, the said FIR dated 7/3/24 was filed by the complainant, owner of the bonded warehouse, alleging that he has misappropriated and transferred a huge sum of money from the bonded warehouse account to his own account, and that he has also failed to pay government dues amounting to crores of rupees. The counsel for petitioner has submitted that the allegation made are false, inasmuch as documents would indicate that as on that would indicate that in the month of August 2021, the relevant statement under bracket annex as annexure 12 in this petition would show that, close bracket, no, would show the
Stock, my lord.
stock
Of the bonded warehouse.
would show the position of the stock of the said bonded warehouse, including the stock at the beginning, the opening stock at the beginning of the month, and the closing balance, which amounts to 41,41078. 41078 means what? Number of
Bottles, my lord. Liquor bottles, yes, my lord.
Number of
Liquor bottles.
liquor bottles.
And then again, next page also, my lord. The continuation, page 1, page 2.
No, total would be.
Total will be 8,338.
So I know total of which amount comes to 8338.
Thereafter, we have shown that September also, my lord.
The Land Council has submitted that the petitioner apprehending arrest in view of such allegation has therefore come before this court with a prayer for grant of anticipatory bail. And at this point of time, for the interim bail granted to be made absolute, with any condition to be imposed by this court, even to the extent of payment of any dues if he is found liable to do so, as far as the affairs of the said bonded warehouse is concerned.
My lord, if my lord may kindly add legal dues, my lord, but the dues, my lord, they may show some papers. Legal dues, my lord.
Legal dues. Legal dues or liquor dues?
My lord, it's all those excise department, my lord, documents if they can produce.
Legal dues, I know. Ms. Per contra, Ms. S. and Leonard J. has opposed the prayer made on the ground that investigation is going on and the investigating officer is yet to confront the petitioner as far as the papers and documents are concerned to verify his assertion vis-a-vis his innocence in this matter, vis-a-vis his plea of innocence in this matter. Under such circumstances, the Leonard J. has submitted that this petition may be dismissed. This court has given due consideration to the submission made. Facts as stated above need not be repeated. Suffice it to say that on the basis of the said FIR file, a case was duly registered as mentioned here and above, and investigation is on. This court, on consideration of the submission made by the parties, would prima facie come to would be made to understand that the grievance of the applicant or of the complainant is that the petitioner herein has misappropriated or misappropriated the amount due and payable or received in the name of the said bonded warehouse, and that the petitioner has also failed or has also failed to pay the necessary taxes or dues to the government. However, it would be a matter of investigation to prove such allegation. However, as far as the cause of apprehension is concerned, this court would agree with the learned counsel for the petitioner that there is apprehension on the part of the petitioner that he may be arrested at any point of time in connection with the said case. Without going further into the merits of the case of the parties at this point of time, considering the fact that the petitioner has also appeared before the IO and has appeared before the IO, the prayer for grant of anticipatory bail is hereby allowed. The interim bail is made absolute, and in the event of his arrest, the petitioner is to comply with the following condition: that he shall not abscond or tamper with the evidence or witnesses, that he shall make himself available to the IO as and when required, that he shall bind himself on a personal bond of 50,000 with 2 sureties of like amount to the satisfaction of the IO or the court concerned, that he shall not leave the where he is staying in Rajasthan.
He is in Rajasthan, my lord, he is staying. As and when he is required,
he shall not leave the jurisdiction of India without prior permission of the court concerned. Is he a passport holder?
Passport holder. Sure. My lord, I'm not sure. We are not sure. But he should not leave, my lord.
If the petitioner is a passport holder, he shall deposit the passport with the IO. And to be retrieved only with due permission of the said IO. Anything else?
Hello, bless me.
Yes, Mr.
My lord, he may appear once every week and as and when required.
Once every week from Rajasthan, my lord, that will not be.
As and when required.
As and when required, my lord, he will be there.
With the above, this petition is disposed of.
Hello, please.
Okay.
Item number 22.
Wait, please, Your Lordship. Your Lordship, I'm praying for an accommodation in this matter as Mr. Shulai is still unavailable. He's the conducting counsel in this matter, Your Lordship.
But as per the last order, the Honorable Court has directed me to produce the evidence of the witnesses already examined. So far, only 2 witnesses were examined. I have obtained the copies. This is a PW. 1 and 2 both are here. This is a 1 and 2 with this evidence, and I was just supplying a copy. And I was expecting there some more witnesses would be examined. But Lordship, the trial is very slow, because the court is fixing one date for productions, another date for evidence, and the date fixed for evidence also witnesses are not coming. And these are the witnesses not concerned to me also. I don't know why the trial is very slow. The prosecuting witnesses.
When is the last witness?
Last
was
day,
examined?
yesterday it was the date.
So,
No witness came.
when is the next date fixed?
After 14 days, maybe it was yesterday. Now it will be another after 14 days. Because
See, the trial court has its own case management system in place. They would know, see, as to the volume of matters in their docket. How they space the dates fixed in a case.
But Lordship, in this
cannot be
case,
dictated to them.
the 15 months gone. 15 months.
From the date the first witness was examined.
Because the first witness was, the charge was framed.
No, let's look at it this way. The date when the first witness was examined was 15 months ago.
No, first witness was
July, Your
examined.
Lordship. As per this deposition, it's July.
Because the charge was framed on 13/2/2024. In the month of February, charge was framed.
We can't go back to that period. Now the point is, evidence has been recorded. And it has started from July.
Yes.
So now we are in September and 2 witnesses have been examined.
Witness examined.
How many witnesses are there?
Only 9 witnesses are there. And 9 witnesses also, these are the witnesses cited by the prosecution.
They may not.
It has got nothing to do with me.
The prosecution may not examine all of them.
But prosecution may examine because there are seven accused.
7 accused.
So the drugs was recovered from the possession of the 3 accused persons, and I was just implicated because on the disclosure statement made by one of the accused that these drugs belongs to me. For that reason, I was arrested. Otherwise, the police could not get any clue, any evidence against me, except my statement. They did not get any evidence. Section 29.
Qureshi, accommodation has been sought for.
Yes, no, I have no objection for that.
Ms. Jadine Leonard J has sought for accommodation in this matter on the ground that the Leonard AAG, Mr. Andy Shulai, who is handling this case, is on bereavement. Mr. Kursi, counsel for the petitioner, has no objection to the prayer made, but has, however, submitted that in compliance with this court's order dated 9/9/2024, copy of the deposition of the witnesses examined by the court, that is deposition of PW 1 and 2 are hereby produced before this court. Accordingly, the same are brought on record and marked as annexure A and B respectively. On prayer made, this is matter after 1 week.
Obliged, Your Lordship.
Item number 23.
Yes, who's the newly
Your Lordship,
implemented?
this new date I filed my affidavit today.
Just recently.
You file your
Yes.
counter.
Yes, yes.
Just recently, I received Lordship yesterday.
Mr. R. Devnath, Leonard Counsel for the respondent number 6 has submitted that the affidavit, counter affidavit on behalf of the said respondent has been filed. To which Mr. Leonard Counsel for the petitioner has submitted that he may be allowed, that the petitioner may be allowed to file a rejoinder to the same. Be allowed. As prayed for, this is matter up to 2 weeks.
23 to 29 connected years old.
That is
23 to 29.
25, 26, 27. Your Lordship, I am appearing here.
So that will be till 27.
Till
Up to
27.
I filed my affidavit. And rest I am not there.
Then 28, 29.
I am not there yet.
20 and 29, I think these are not, no affidavit is required because no one has been pleaded here.
So in this case, I am not there. Your Lordship.
No, because this is only for prayer for salary.
Salary, yes, area dues.
Katusha, I will list this matter up to 2 weeks.
I'll update you.
Item number 31. This matter, the order for miscase maladies.
Yes, the miscase have not yet been able to prepare the.
Madam.
So we'll list this case after.
After puja vacation.
Lordship, the written argument filed by the, my learned friend, I have not received till now.
Lord, I'll supply it today.
Then now you want to get a copy and then respond to that.
No, Lordship, at least I should be aware of what the arguments they are placing on records. I am.
You read my order. I will note down what they have said.
Lordship.
So that'll make it easier for you to read.
I'll supply it today.
Give it to her. On pre-made by the parties, list this matter after 2 weeks.
Item number 32. Item 32, my lord, these matters are those new matters, my lord. This.
Oh, you're ready?
Today, my lord, don't be ready, your lordship.
She's ever ready. Why? What would you?
Lordship, may I fix it after vacation, my lord. So,
Vacation after vacation will come.
my lord.
This matter will not be. No further.
We'll file a.
Look at the order.
My lord, I have seen the order. My lord. We'll file a written submission also, my lord.
How can you file written argument when
My lord, we'll just place a bulleted point, my lord, for ready reference, my lord. My lord.
you have not even started your argument? How do you place your written argument before that? Compilation I can understand.
My lord, it's a kind of compilation only, my lord. We'll file it on the day of hearing, my lord.
Ms. Shalam is smiling, so she knows you are on a bad wicket. Mr. Learned Counsel for the petitioner has once again sought for accommodation, but has however submitted that the petitioner may be allowed to file relevant a compilation with relevant authorities to be placed before this court in support of his case. Yeah, I common order ni. Oh, so to send you ka jong nay. In support of that case. Ms. Salam, the counsel appearing for the respondent, has no objection to prayer made. Accordingly, on consideration of the submission made by the Learned Counsel for the petitioner, matter is now posted after 2 weeks.
Item number 35.
Please, Your Lordship. Lordship, this is that Shillong Club matter. On the last occasion, Lordship had stated that Lordship may want to examine whether Lordship can take up this or should take up this matter.
Like you said, yes, I've had some connection with the deceased.
That was 30 years back, my lord.
30 years back, more than that. Of course, it's up to parties.
From our side, my lord, like stated from the last time also, we have absolutely no objections or any sort of problems, and I'm certain that same is the case with Mr. Asu also.
So what do we do?
I'm ready.
Senior counsel may start the arguments. Senior counsel will join. It's unlexed right now.
We start or we wait for you?
The petitioner may start.
Because this matter will take some time. If I can pray for next week, my lord, because it's a very substantial matter. It's already 3 o'clock.
Yeah, now
3 o'clock, my lord. It's a little too late to start.
See, Mr. General.
Yes, ma'am.
We take it by our standard. 3 o'clock is late for us. You go to other High Court.
No, absolutely. Because I'm
6:30 is normal.
Because I'm in this honorable High Court, I can dare to say that it's a little late.
But that you see, that would not be applicable for us.
That's true, ma'am. That's true.
As long as we can keep our eyes open, we are there.
That
if I happen to fall asleep along the way, it can't be helped.
No, Lordship is still young, my lord. The rest of us, my lord, we are falling asleep. So if Lordship can take it next week, maybe.
Oh, we take after vacation then.
After vacation, very good.
And pray made by the parties. This is matter after Durga Puja vacation.
Item number 36.
Yes, what are the instructions?
Instructions.
You are supposed to receive instruction whether the petitioner would.
Petitioner wants to press the matter, my lord.
Okay.
Petitioner wants to.
Okay, we are talking about that advertisement.
Yes, ma'am.
Which has subsequently been issued.
Yes, ma'am. So
you file a review. You see the review.
Yes, ma'am.
Well, it may have become infructuous.
Not really, my lord. Not really. In fact, the attempt was made by the respondents to try and impress upon this honorable court that there have been some developments in terms of another person having been appointed, etc. Against that other person's appointment, there is some other writ petition pending in another court.
But look at
my response, my lord, is very simple. That I will show how the matter is not yet infructuous, in spite of these other developments.
Because I have not gone through the petition as such.
Yes, ma'am.
But I would understand this that this court has passed an order.
Yes.
Pursuant to that order, the advertisement was floated.
Yes, ma'am.
And the process was completed.
If I can just clarify. If I can just clarify, Lordship passed the order sometime last year. After Lordship, the finding in Lordship's order was, with respect, that the advertisement, the original advertisement, was defective because of some reasons, and Lordship was pleased to set aside that original advertisement. And having set aside that original advertisement, my appointment plus private respondents' claims, etc., they all came to naught, my lord. There was also a direction from in Lordship's order that to issue fresh advertisement. Lordship's order was passed in July. Fresh advertisement was issued in August last year, my lord. Upon that fresh advertisement having been issued, we filed the review petition, my lord. This today's review petition. Possibly because of the pendency of the review petition, that advertisement was never acted upon from August last year, my lord. Because
this review was filed earlier.
Yes, my lord. So because of the pendency of the review, matter was sub judice, etc., that advertisement was never acted upon, my lord. Matter proceeded before this honorable court. The review matter proceeded. I concluded my submissions, my lord, this year in June. In June, if Lordship sees 25th June, I concluded my submissions. And my friend wasn't even present on that day. He should have had the courtesy to take steps to mark his presence at least.
In any case, you have to refresh this.
Because, yes, ma'am, what I'm trying to say is, because my friend was not present on that day, Lordship was pleased to give him one more chance. And on the next date, he took some time, and thereafter he informed this honorable court that there are fresh developments, etc. Some other person has been appointed. That other person's appointment is under challenge in the writ petition. So to absolutely.
Anyway,
why does he keep interrupting me?
How is it connected?
Was I making submissions on that other case?
That is always the. I've seen that's always the norm here.
No, it's unprofessional. It's discourteous.
It makes for interesting banter.
It does. It makes for an unnecessary interesting. To get back to the subject, my lord, matter has not become infructuous. I'll show how matter is not infructuous in spite of the fact that there is a subsequent development. It's very simple, my lord. Because if Lordship agrees with me that there is a ground for review, and Lordship would kindly recall my submissions. My review, my lord, my submissions, my grounds of review were not on the merits at all. I did not go into the facts, into the merits, etc. My ground of review was a single ground of review. My ground of review, and I had taken my lord through the record, was to show that there was no averment in respect of the writ petition in respect of the advertisement in the writ petition, there was not a single ground taken against the advertisement. There was no prayer against the advertisement. Consequently, in the replies that we filed, the state respondent also filed, there was not a single reference made to the advertisement. During the course of argument, there was one reference made by my friend in respect of the advertisement, a one-line throwaway reference. That was all. In spite of that, and I have to place all this with all respect at my disposal, in spite of that, this Honorable Court found it proper to set aside that advertisement. So my point through this review petition is a very simple point, my lord. Based on the law, which also I had placed on the last occasion, based on the law, there is no reason, or there is no power that lay with this Honorable Court to set aside something which was not challenged, my lord. So prayers granted in proceedings have to be based on pleadings, etc. The law is very well settled. Lordship is also aware of the law. So because there was no pleading, because there was no challenge raised, with respect again, Honorable Court could not have set aside the advertisement. Now, as I was saying, if Honorable Court agrees with me, then the judgment passed last year in July will be reviewed. If the judgment passed last year is reviewed, the direction to issue a fresh advertisement will also have to go. So therefore, the subsequent development which has taken place will also, in a way, amount to a nullity, my lord. So therefore, it is in fact the other case which is under threat from this case. It is not because of the subsequent developments that my review petition is under threat. It is because of the pendency of my review petition that the actions which have been taken in spite of the pendency of my review petition, that is under threat. Because knowing full well that matter is still sub judice, they thought it convenient enough to take steps after a year of issuing the advertisement in the middle of the hearing, my lord. They ran the risk, my lord. They ran the risk. Hearing, I finished my submissions in June. They took steps in July for appointing the new candidate. So my point is very simple. To just on the point whether my proceeding has become infructuous, it has not become infructuous. In fact, if I succeed, the other proceeding will become infructuous, my lord. So my lord, if lordship is inclined, I can refresh lordship's memory. If lordship chooses to.
My friend is intending to argue the matter. Lord, today I am not. I have some personal difficulties. Let this matter come up after vacation, my lord. Whatever submission is making, my lord, plain and simple, it's, my lord, highly misleading. Nothing else.
Either he's prepared or he's not prepared. Either he's taking time or he's not taking time. He can't have it both ways.
He was supposed to take instructions whether to withdraw the matter or not.
No.
Today he comes and says that no, I'm ready for the hearing. Nevertheless, my lord, if my friend is ready for the hearing, we'll take up after the vacation.
We'll take up the matter after vacation.
Yes.
Very well.
We will take it.
On premier of the parties, this is matter after Puja vacation. It'll be interesting. Because this court will have to consider. Now, since the order has already been passed, action has been taken on the virtue of that. How
as lordship had himself opined few days back when I pointed out that all this is going on and urgent orders are needed, I had filed a miscase also. What again is interrupting.
See, now the case is over. You can quarrel, but you can extend your quarrel outside the court.
No, only inside the court.
So, as lordship had himself opined, something that is done can always be undone. So, a lot of water may have passed, but there is.
We will have to see what is the basis.
Absolutely, the circumstances are important.
Interesting factor. So what is the basis?
The circumstances are important.
Now, apparently, the option before you is to go for an appeal, which according to you may be the proper course or not. That is up to you. But that may be the opinion of this court. Anyway, we'll look at it.
Very well. Very well.
This is you.